You ready?
You're probably going to have to give them the same speech that you give all the other ones. There has to be some unique reason, that speech.
You ready? When you are, yes. Okay. In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should state so at this time. Seeing none, I'll have the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay.
Mrs. Hutchinson?
Here.
Mr. Murray?
Here.
Mrs. Werner? Ms. Hessel? Mr. Ledwin?
Here.
Mrs. Notch?
Here.
Mr. Walsh?
Here.
Mrs. McDade?
Here.
Mr. Venuto?
Here.
Thank you.
Okay, we need a motion to pass the minutes from February 24th to 2022.
So moved.
I'll second.
Okay, we have a motion by Mr. Murray, seconded by Mrs. Notch. Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Mr. Walsh?
Yes.
Mrs. McDade?
Yes.
Mr. Venuto?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
Yes.
Thank you.
Now we need a motion for the minutes from March 24th, 2022.
So moved.
A second.
We have a motion by Mr. Ledwin, seconded by Mr. Walsh. Mr. Walsh?
Yes.
Mrs. Notch?
Yes.
Mr. Ledwin?
Yes.
Mrs. McDade?
Yes.
Mr. Venuto?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
Abstain.
Thank you.
Okay, we have a resolution, 42822. It's Washington and Madison LLC, 722 Beach Avenue. We have a motion to accept that resolution.
So moved.
Second?
I'll
Second.
Okay. We have a motion by Mr. Murray, seconded by Mr. Walsh. Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Mr. Walsh?
Yes.
Mrs. McDade?
Abstain.
Mr. Venuto?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
Abstain.
Thank you.
First application tonight is Cape May Sea Glass Properties LLC at 933 Beach Avenue. Do you want to come up? Hi, Drew.
Hello. Thank you, Madam Chair, and good evening, everyone. For the record, Andrew Catanese of the Monzo Catanese Hilligus Law Firm on behalf of the appellant, Cape May Sea Glass Properties. Its principal members, Bonnie and Sean Wilhelm. This is Bonnie Wilhelm to my left.
I'm Robert Feinberg, solicitor to the Cape May Historic Preservation Commission, and I'm here for the respondent, and I believe this seat is still warm from the last time I was here.
Okay.
Or maybe it's for this one, I don't know.
Thank you. The subject property is located at 933 Beach Avenue. It is the site of two different buildings. They are both classified as non-contributing structures by the Historic Preservation Commission. The project involves various improvements that will result generally in the reduction of units from 11 pre-existing units down to 7. Importantly, to this application, as part of this project, it was improved to elevate the house to bring the lowest habitable floor area up by about 2.8 feet. The record of proceedings below confirm HPC granted conceptual approval in April of 2021. That was about a year ago. This zoning board granted final approval with variances in August of last year, and the HPC then granted final approval in September of last year with conditions. And succinctly, we have filed this appeal requesting removal of one condition of approval. That condition prohibits using the ground level of the main building for parking. This may trigger us to talk about the second condition imposed by the HPC, which was the removal of lattice doors to that driveway entrance. The Wilhelms don't take a position on that, though we think it would be appropriate to follow the originally approved plans here at the zoning board. Generally, there are two reasons why we think the HPC decisions should be overturned. Number one, we don't think they had jurisdiction to even consider the issue of parking on the ground level. And second, even if they did, we think their decision was arbitrary, capricious, and unreasonable. We've really laid out our argument, I think, in depth in the brief we've submitted. I'm not sure if you've had an opportunity to submit it. I do know that, of course, 8 months has passed since we were here before you, and I do think I see a new face or two. So with that background, I would like to just share a couple documents from the record, refresh your recollection, and get to what I'll try to keep as a relatively short overview of our argument.
Mr. Catanese, can you move the mic a little closer?
I can.
Thank you so much.
Now, these are all in the record. This is nothing new, of course. These are just larger copies. It'll make it easier for me to explain generally the project. What you see on the first page is a photograph that was submitted to the HPC showing the house as it originally existed. I've highlighted in yellow the driveway that really was the impetus for this building elevation issue. On the second sheet, Z4, I've shown and highlighted the existing front elevation and proposed front elevation. And the issue in this case, if you may recall, was the fact that that driveway dropped down below the adjacent grade. It needed to be lifted to meet the flood code requirements. And when it did that, it would have cut off any access to the back of the property for vehicles, which necessitated lifting the house that 2.8 feet that was approved both here and at the HPC. The final page, sheet 2, shows the parking that this board made a condition of approval be inserted on the plans. I've highlighted that in yellow. So what that site shows, what that plot plan shows there is cars would enter from the street, travel to the back. There is parking under the rear building that was approved by the HPC. What's in question are the 4 spaces that you see highlighted there. And the question becomes that, the HPC's position clearly is that that area should remain open area, not designated to any use, instead of using it for the parking of cars. Now, on the first issue, the one of jurisdiction, I've briefed this. I want to try to move it along, but I don't want to shortchange the issue, and I want to make sure that we're clear on it. The HPC really has a dual role, and it depends on whether a project requires planning board approval or zoning board approval, or whether it's a type of project that goes straight to the construction and zoning office and obtains a zoning permit. That is, does a project involve an application for development? That's the buzz language that we see in the state statute. Where an application for development is required, where an applicant will come to the planning or the zoning board, the HPC's role, first and foremost, is advisory to the planning and the zoning board, and that's in section 109 of the land use law. That's why our HPC does not, or at least should not, ever grant final approvals on an application that has to come to one of the boards until it's been to the board. It's why we go there for conceptual first. It's why we then come to the board for the board to make its determination and return back to the HPC for a final approval. The HPC has every opportunity and is invited to advise the planning board or the zoning board on those applications so that the boards can consider the HPC's concerns when it makes its decision. But once decided, the HPC's role in any later application for a construction or zoning permit is limited. And that's the important part of this. Section 111 of the land use law says that where a town has a strong HPC, which Cape May does, any application for a permit, typically after a planning and a zoning board application, has to be referred to the HPC, and here's the language from the statute, for a written report on the application of the zoning ordinance provisions concerning historic preservation to any of those aspects of the change proposed, which aspects were not determined by approval of an application for a development by a municipal agency pursuant to the municipal land use law. It's a bit of a mouthful, but what it says very simply is that when a planning or a zoning board determine any aspect of a project, the HPC no longer has jurisdiction over that aspect of the project. Now, that statute is mandatory. It's the municipal land use law. It's statewide to every HPC that exists, if it's a strong one. But to alleviate any doubt, the city's historic preservation ordinance repeats it. It says, on all matters referred to the commission which require approval by the planning board or zoning board of adjustment, the decision of the commission shall be a recommendation only. It's section 38 of our code. Our local ordinance also restates the statewide limitation on the HPC's jurisdiction in these cases. Our local ordinance says, an approval by the planning board or zoning board of adjustment, as the case may be, does not relieve the applicant of the requirement of obtaining a certificate of appropriateness for those aspects of the change not approved by the application for development. And this makes perfect sense, because it would avoid putting applicants in the position that the Wilhelms now find themselves in, with 2 approvals for the same exact building with conflicting conditions that could not be rectified. Only one board has primary jurisdiction, and that board is you. Now, in the present case, your resolution was clear. This board already considered the issue, not because the HPC actually advised you and gave that advice that it could have, but because we brought it up. Right? We knew this was an issue for the HPC, and when we came before you, we explained why the area under the building was not dedicated to parking. And your resolution, knowing all that, found that there is going to be a driveway under the building, regardless of whether the parking was permitted on the left side, that the parking can be done so that it is not visible, that there's no dangerous precedent created by this, and this board importantly explicitly conditioned approval on placing the parking under the building, stating that if the HPC disagreed, the applicant shall appeal it back to this board. So you really have in effect, already decided this appeal, because we made it certainly known to this board before. Our analysis can stop there. There's also the second point of this, which is the arbitrary, capricious, and unreasonable standard. The HPC's resolution says there was much less paving in historic times, and introduction of large areas of paved driveways and off-street parking has altered the city. But whether this area is used under the building for parking or not, the area is entirely within the building. It doesn't in any way increase paved areas or create large areas of, paved driveways. It has no impact. The HPC decided that off-street parking should be located as unobtrusively as possible, whereas this parking is going to be inside the building. That's unobtrusive, and I think it's unreasonable otherwise. The HPC even determined that additional cars going to and fro would be visible from the street, and that was another reason to decline the application, or I should say impose the condition. Cars coming to and from are nowhere in those HPC regulations. Parking and where you park them is, but to say that we have a driveway and the addition of the additional 4 parking spaces is contrary to the HPC design standards is incorrect. So we also noted on the record, and frankly we brought it up only as a response, that it's inconsistent with prior approvals right on this very block for a contributing structure that was approved to be developed with ground floor parking, whereas these structures are non-contributing. So the bottom line of this application is the house has been approved, it's going to be lifted. The HPC would have this 7-unit building have only 4 parking spaces in the rear and have a big wide open interior swath of the main building sit open and unused. And we don't think that's reasonable under the circumstances. For all those reasons, we would ask that the condition be extracted. Now, like I said, the second condition or issue for us to talk about is whether, going hand in hand with that, this board wants to eliminate the condition that that lattice door that you see on those building elevations I provide you should be removed. The HPC, when they, I think the comment on the record was it goes hand in hand, that when you take away the parking, you need to have that door to shield it. But again, we don't have a position on that, except insofar as, to the extent this board has approved it, we think, once again, that that decided the issue. So with that, I'll finish up. I'm happy to take any questions. Of course, I know you're going to hear from Mr. Feinberg, but I don't want to go on what I think is a relatively straightforward issue.
Anybody have any questions for Mr. Keyes? No? Okay. Mr. Feinberg?
Thank you. I have with me tonight Warren Copeland, Chairman of the Historic Preservation Commission, and he has been the chairman at all times, material regarding this application. As indicated by Mr. Catanese, this is not a rated house, yet it is within the historic district, and therefore comes within the purview of the Historic Preservation Commission. I just want to begin briefly by emphasizing the standard of review. I know that this board is familiar with it, and I know that Mr. Hurlis is going to, in his comments, recite it again, but because of its importance, I'll just take a sentence out of it. As recited by Mr. Hurlis in his memorandum of January 11, 2022, he indicates the appeal shall be heard on the record, made before the Historic Preservation Commission, a determination by the Historic Preservation Commission on issues within its authority shall be entitled to due deference. And I sincerely hope and trust that this board will take that to heart. The decisions of the HPC should be afforded due deference unless you truly find error in what they did, and we'll review that in a minute. Mr. Catanese began by reciting his 2 points, the basis of the appeal. I think he went into a third, dealing with a precedent on another property, and I will separately deal with that. But the jurisdiction issue, that's a very important issue. And I'm going to take a few minutes to deal with that, because the way that this board looks at that issue affects not only this application, but as I see it, all future applications that may involve what you do on development applications. Before I do that, I do want to point out
Mr.
here.
Feinberg, I'd ask that you limit your comments to this application.
I am, yeah. But I think the result goes beyond this application.
That's a
But I will.
legitimate opinion, but that's not what we're doing tonight.
Understood,
It's not fair to the applicant, so just
understood.
focus on this application.
Yeah, I don't intend to discuss anything other than what's here before you. I think Mr. Catanese indicated that the Historic Preservation Commission had the opportunity to comment on this application when it was before you. And indeed, they had an opportunity. But what they did not know, and the applicant did not know, until they were before you, that the issue of parking underneath, that you would require parking underneath this building as part of your approval, that you would condition it on that. Had that been known in advance, obviously, the Historic Preservation Commission would have wanted to be heard. But that issue wasn't raised, that requirement wasn't raised until the hearing itself. Our position is that certainly the commission has it and had the jurisdiction to deal with the question of parking underneath the house. And to explain why, I think we have to go into the process a little bit more detail than Mr. Catanese presented to you, and if you'll indulge me for a minute. see that. What I've got here is simply a copy of what is in the design standards that govern what the HPC does. These, as you know, are part of the zoning ordinance of the city of Cape May. They've been adopted as part of the zoning ordinance. So they guide what we do as a commission. These are pages 5 and 6, if I recall. Yeah, pages 5 and 6 of the
Marking
design
report
standards.
A1,
Pardon me?
I'm marking report A1, pages 5 and 6 of the guidelines.
Thank you. The reason this is here is to really present in a flow chart form what the process is, so everybody is crystal clear about this. And it's headed Historic Preservation Commission Legislative Authority. When an individual property owner wants to do something with their house, it's going to eventually require a building permit. There's two avenues that have to be followed. One is the development process, which involves zoning. The second is the permitting process, which involves the HPC and the construction official. They're separate and distinct areas that must be followed. There's even a third, if we want to call the construction permit itself another process, because the applicant has to meet the construction codes. But we're not dealing with those tonight. We are dealing with development, and we're dealing with the construction permit. So it begins with an application for development. Handy dandy. There we go. Okay. It can go to the planning board, and if it needs what the planning board can approve, site plan variances. And the planning board makes their hearing. Once they make a decision, as Mr. Catanese indicated, it's then referred to the HPC. And the HPC makes their determinations based on the design standards. And at that point, their decision, if it's altered what the applicant wants to do, goes back to the planning board and then to the construction official. Once the development process is over, it then goes to the construction official for the issuance of a permit. That's a different process than the development application. So you need a permit. I included the planning board and the zoning board here, depending on what the particular issue is between those two boards. But it winds up back with the construction official to actually have the written permit issued. He looks at the application, he looks at the plans, he looks at what the development board did, and makes a decision as to whether or not that application has to then go to the HPC or not. They may be doing something which is perfectly within the design standards, it doesn't need HPC approval, in which case he issues the permit. Or he can say, no, this is not consistent with the design standards, you do have to go in front of the HPC. So the HPC hears it, they make a determination to approve or not approve it, which the statute calls a report, our ordinance calls a certificate of appropriateness. It's a document that goes to the construction official, and it says to the construction official, we have approved this, we've issued a certificate of appropriateness, at which point the construction official issues the building permit. Or the certificate of appropriateness is denied because the applicant hasn't met the standards, in which case that construction permit is not issued. Under our form of government, what the HPC does here has to be accepted by the construction official. In other words, it's mandatory. There are some forms where it's simply totally advisory, but not mandatory. In our form, it is mandatory because we have, as you know, a unique community in terms of our architecture. These processes are separate and distinct. One deals with the typical application that you get, hard and fast numbers, setbacks, height, locations, size, use. The other, a little bit more, I don't want to say nebulous, but not as distinct. The HPC is governed by these design guidelines. You can have an issue like parking, which can be looked at in different ways. One way to look at parking is the way you looked at it. Well, it makes sense to put this under the house. That space that could be utilized for parking, that's good zoning, and I'm not arguing against that, it is. But the other way to look at that is the design aspect of it. Does that meet the design standards? Is that appropriate for a house in the historic district to have parking underneath the house and have access to that in and out underneath the house? Is that appropriate? Do you see that throughout the district? If you don't, and the HPC considers that contrary to the intent and good design, then the HPC would not approve it. So
Mr.
you could have,
Feinberg, let me interrupt you for a second. Mr. Katney said that there was another house on the same block in which parking underneath the structure was approved by the HPC. Is that correct?
no,
It's not correct, okay.
no.
Okay, well, I'll let you
Flat
finish,
out,
I'll let
no.
you finish on, because that is a difference of
It is. and
facts here. Okay,
I'll get to that in a moment.
all right.
No, I think,
I'd rather not. I
we do
don't
it?
know that it matters at all.
I agree with
Oh,
you. It's
wait,
not-
well, I'll tell you, we have to make the decision here, okay? And part of the decision is whether it's arbitrary and capricious. So if they approve it on one hand and disapprove it on the other, that is very important for us to make that decision here. So I think it's
I
very
understand that,
apropos.
but the problem is an appeal based on the record below.
It
So
isn't, well, it's stated in the record
I
below.
understand that they said that, but I don't even know they said what property it was. Is there any?
Yes, they did.
Yeah.
It's in the
Do we have-
record.
Do we have the, I mean, I read the transcript.
yeah.
So did I. It's in
So
the
do we have
record.
the property? Do we have the evidence? Do we know what it looks like? Do we know what happened? Do we have the plan?
Went to see it today, so.
All of that is no.
Hold on. I know, I just want to, it's not that, I'm just saying that we got to stay with the record that we have. So if we're going to get new evidence today about what it looks like and what happened with that property, and if.
I would
if
not
it
have
was-
raised it unless it was in the record. I looked at the record very, very closely today.
Bill,
It's in the
Bill,
record.
Bill,
Okay?
I understand
I just
that.
want to make sure that
I
we're
just-
doing the appeal correctly here.
Well, the correct way to do the appeal is to not have new evidence.
I
So
know that.
I just want to make sure that the answer to that question is, there's something in the record that they disagree as to whether this was done before. But I guess to make that decision as to which one of them is right, I think we have to go beyond the record. We have to get what happened in that incident, and I don't know that that's in the record. So I just, before we go down that path and they start answering the question, and then Mr. Feinberg gives a history of what he remembers that happened at that hearing, and Mr. Katniss tells us what he talked to the neighbor about, what really happened at that hearing, and we developed this whole new record about some application that's really not even before us. I just kind of want to stay focused on this application.
Yeah,
If I may.
And that's the problem, Bob. So,
That's
Mr.
right.
Murray, that's what I want to,
I don't think we should argue amongst ourselves. I just want to make sure
I'm not
that I
arguing
saw
with
the record.
If I
Okay?
may, the reference to that other property, and it was
Okay.
identified as 905 Beach, appears on page 11 of the transcript.
Yep.
It's lines 10 to 14, and this is not testimony from the applicant or the applicant's representative, Mr. Clausen. This is argument from Mr. Catanese. Mr. Catanese says, quote, "It is our understanding that this would not be the first building that was approved for parking underneath, with one, I believe, at 904 Beach Avenue, having previously been approved by the HPC. He further stated that it was a block away." That's all that is in the record about this property. There's no testimony from an applicant. There's no detail presented with regard to that property. So I do agree, it's not part, this shouldn't be a consideration. But to the extent that it's been raised, and what I'm going to say next also should not be a consideration, but it has to be said. This property was before the HPC on August 20, 2018. Property owner is an
hold
individual.
on, wait, we're doing the exact thing I said we're not going to do.
Well,
So, Mr. Katniss, what's your position on whether we can go beyond the record of those 4 lines? Now, if someone wants to submit as evidence a document of this board or the HPC, the resolution, I guess I would hear some conversation about that. That's a record that's generally available, and that's not testimony, it's a existing, something we could take judicial notice of in a sense. But beyond the resolution, you're describing what happened at a hearing, and then you're telling us what you went and looked at, or what you read, or talked to you about. That is just not something we can do on an appeal in the record. That's why we asked for the transcript. So I just, if it was something really critical, like since the last hearing, the building had been knocked down, or some other fact that had to come in for this to make sense, I'd say yes. But the fact that you may have done something similar previously, it's not so critical that we need to expand the record. What do you want me to do? Do you think we should expand the record, Ms. Katniss?
I don't think it's necessary.
And
For
Mr.
my part,
Feinberg
and
agrees.
yeah, I just want a little clarification on it. So the board members here understand. That statement was made in response to a spontaneous comment by one of the HPC members, which appears on page 8, that says, "This commission has not approved parking under a building in the historic district." So effectively, what we did, ill-prepared for that statement, which we didn't expect because we didn't think it to be fact, we asked the board effectively on page 11, to take notice. I didn't have my glasses on when I said 13. To take notice of another nearby property on the same block. And that's what's in the record, and that's what we have today.
Okay, now, the record does not show that the HBC disputed your statement, right?
That is accurate.
Okay.
There was no response to my statement.
All right, there was no response, right?
well, Mr. Copeland disputed it in saying that we hadn't done it.
I didn't see that on the record. I have it in front of me.
Well, he said that his statement was in response to Mr. Copeland.
Yeah.
He argued that you had, but produced no proof of that. Mr. King, I have the resolution that we're talking about here, and it will, I'll represent to you, and you're free, and I have copies for everybody. It will indicate there was no application for parking underneath the building, nor any approval given for that. None
Well, has
whatsoever.
Mr. Katniss had a chance to read the resolution?
I have not.
All right, well, if you want to put it in evidence, let him read it, and then I'll hear from both of you on whether we're going to put it in.
I can do that.
I'm not even sure that if they had done it once before, that would make it arbitrary to do it again, but Mr. Murray is interested in it and deserves to have all the information he wants, so, but I think the best I can do is the resolution, that's a city document that is the finding of the board, the HBC.
Rich, on page 7 of the letter, there's a whole half a page of writing about this. There's
Yeah,
correction
well,
maybe.
a brief isn't evidence.
Oh, okay, okay.
So, the argument you can consider, but,
The record, though, isn't it?
what's that?
It's on this is the record, though, isn't it?
See, evidence is something that comes in at a hearing, and then it can be cross-examined or challenged by additional evidence. The hearing that occurred is the HPC hearing. So if they wanted to have a fight about this other property, then there should be witnesses that come in and testify about what happened at that property, and then Mr. Katniss can cross-examine that witness, or Mr. Feinberg could cross-examine that witness, because the danger on, now, that's the record that comes to us. And that's what they based their decision on, was that record. And we're reviewing whether that decision, well, we're reviewing more than that, but we're reviewing whether that decision was arbitrary, capricious, or unreasonable. Okay, we also have this jurisdiction issue, which is slightly different. If Mr. Katniss puts certain things in his brief that are factual, that would be evidence, that would be an inappropriate way to bring it before the board, because it's not in the record below. So if it was just a matter if they mailed it to us 2 nights before the hearing, and they could add to the record, that would be an ineffective way to review the record below. That's why we get the transcript. So we really should limit it to the record below, because what happens is, tonight we could hear about 4 other properties, and we'd have to take all the evidence on those, and that's not really what we're supposed to do, because then we'd be deciding it for ourselves, and we wouldn't be deciding what the HBC did, because they didn't have any of that. Okay? So that's what we're trying to do here, and really, if it was something super critical, I can make exceptions for it, okay? But We have a huge record on this. We heard it already once. We heard all the reasons for 2.5 hours, okay? And then it went back down, and now it's back before us. And honestly, it's the same issue we decided before. So new facts aren't terrifically relevant. It's legal argument, okay? So I know this was said down there, and there's 4 sentences about a property we don't know anything about. So have you reviewed it?
I do not have an objection to this going in the record.
Do we have 12 copies of it?
I did.
Yeah, I think everybody has it.
Oh, this is this thing here? Okay, well, should we read it instead of talking?
I'd like to be heard on it, but that can come later in rebuttal.
Mr. King,
So you can tell me all the things that aren't in this resolution. Right.
based upon your comments, you probably don't want to see my notes of that meeting, 2018. Okay. I don't want to belabor that any longer.
No one wanted to listen to me, so now we're stuck with it. So let me read it and read the
Okay.
resolution, and then we'll deal with, what property is this? We'll deal with block 1081, lot 24, and then we'll get back to the actual house at issue. Bob, can I just read this?
Yeah.
Thanks. Was this before or after the flood adaptation ordinance? Was this before or after the ordinance that was passed about raising houses?
Before.
All right, go ahead. Is everybody ready to move forward? Have you had a chance to read the resolution? Mr. Mayor, have you had a chance to read the resolution, sir?
Well, I'm not exactly sure what, this is the resolution on the Allison house that was down the street, Mr. Feinberg. This is the one that purported to raise the house and let parking underneath?
Yep.
Okay. Just want to make sure I understand what it was. Okay.
Okay, go ahead.
That's a good point that you raised, Mr. King, because the flood mitigation ordinance, the federal flood standards didn't come about until 2019. The last point I would make with regard to the process and why the commission has jurisdiction to hear
Mr. Feinberg,
part-
there's people in the audience that can't hear you. Can you speak into your microphone, please?
Sure.
Sorry to interrupt.
Is that better? Okay.
Thanks for the light, Karen. Okay. Now I can read it.
Finally.
Basically, with the jurisdiction issue, I think Mr. Cadney's is simply interpreting that statute much too broadly. If you accept an interpretation like that, then all an applicant would have to do if it came before you and say, oh, by the way, I want to put on shingles, not a wood roof, or I want to locate my house over here, not over there. What do you think? Or, on and on with various elements. And if you deal with that, then you're saying, well, we're taking that jurisdiction away from the HPC, and that's not what the legislator wanted. The legislator wanted the HPC to deal with aesthetics, to deal with design. So you can have the same element, but look at it from two different perspectives. It's another, if I can say, another layer of regulation that is the case when you live within the historic district. It's a method of preserving those houses, and that's really all I can say. And I think there's ultimate recognition by this zoning board of that fact, because even in your resolution, paragraph number 13 of your resolution on page 9 notes that the project is located within the historic district. Historic District Commission approval will be required. It doesn't carve out exceptions. The question of arbitrary and capriciousness, the second point that Mr. Catanese raised. I think those were dealt with within the HPC resolution itself. Obviously, the HPC knows that they have to have reasons to do what they do. If they have no reasons, then they would be arbitrary and capricious. They have to set out the reasons. And this resolution does that. There are reasons and references that you may not agree with if you were making the decision. But if they were reasonable to the HPC and they're not unreasonable, they're not picked out of the air, then the deference ordinance comes into play, I would submit. So if you look at the resolution, which is part of the packet that Mr. Catanese submitted, it goes through the history of this application, and skipping down to the 4C, it makes reference to the Cape May Design Standards. Again, the booklet that I held up. And it refers to a specific page of that standard. That's page 64, dealing with off-street parking, paved driveways and off-street parking.
I'm
And
sorry, what are you referring to? I have the resolution here.
this is the HPC resolution,
resolution?
2021-34.
Okay, I have it in front of me.
Okay,
And what page?
and I'm referring to page 2,
Page 2,
reasons for the action of the HPC.
okay?
That's paragraph 4, beginning with C,
Subparagraph C, okay.
right?
Okay, gotcha.
And in that paragraph, it references the Cape May Design Standards. It references page 64 and quotes from those design standards. It's noted there was much less paving in Cape May in the 19th and early 20th centuries, and most buildings were surrounded by landscaping. The setting of many historic buildings and the character of the city as a whole have been altered by the introduction of large areas of paved driveways and off-street parking. It's further noted that, quote, new driveways and off-street parking shall be located as unobtrusively as possible. Locating off-street parking in front yards is not appropriate. Locating off-street parking in the side yard is not appropriate if the area is visible from the street or the front yard. Driveways and alleys should be used to access side and rear parking areas and garages. Abutting new driveways and off-street parking areas to historic structures is not appropriate. And then it refers to this specific application, the proposal for a drive-through under the existing building would be used not only to park vehicles in the rear, but also to park vehicles underneath the main building. That contradicts the policy statement in the design standards that driveways should be used to access rear parking areas. Homes in the historic district typically are not designed or utilized for parking underneath the building, whether visible from the street or not. Certainly, the additional proposed spaces for 4 vehicles and the traffic generated to and fro by these 4 vehicles will be visible from the street.
Okay, part of that, paragraph C says, off-street parking shall be located as unobtrusively as possible. You think that parking these cars under the house behind the screen is unobtrusive?
Once they get there, but they have to get there. And they're getting there, and they're doing their movements outside of that area to get there. In fact, it was, let me, if I may, quote another portion of the transcript. In Mr. Cananese's brief, actually, page 7, he says, utilizing the area under the principal structure, which is largely hidden by the 4, can't read my own, the 4 walls, the foundation walls, by the foundation walls. So he uses the term largely hidden. He doesn't say hidden. It's something that can be seen going in and out. And it's a high volume. He's suggesting doing this with 4 cars.
Mr. Feinberg, there's 7 units there. Where are these, they're still going to have to park in that driveway to unload everything, and there's no place for them to go. That's why we said they needed to have on-site parking. I don't understand. I mean, it's hidden. It's under there. You can do landscaping if you think you can see it from the street, but They have to park somewhere.
I understand. Frankly, I think that's an issue that would warrant further review to see what solutions there may be. That wasn't the issue before the HPC, where off-street parking should go, only where it shouldn't go. And it shouldn't go here.
In the
So-
design standards that I see, excuse me.
No, that's okay.
It doesn't, these were made, and it didn't specifically say in this book on page 64, it doesn't say anything about parking under the buildings.
Which design standard says you can't park under a building?
No, it doesn't use the word under the building.
No, it doesn't say that.
It talks about they should be as unobtrusive as possible. You can't have in front yards, you can't have off-street parking in the side yards, if the area is visible from the street or the front.
But Bob, where does it say you can't park under the building? That's the design standard, that's the entire basis of the decision, is that you can't park under the building.
Because you
So,
have,
I mean, let's assume for sake of argument, there was a design standard that specifically said you cannot park under a building. Okay, let's assume that that existed, which I don't see it, but assume it did, okay? And who would decide if there was a circumstance that under all of the circumstances, there should be an exception and you should be able to park in a particular building? Who would decide that?
if there were circumstances,
Assume that it said what you say it says, and it said that there's the design standard that says you cannot park under a historic structure. Suppose it said that. And then there was a circumstance where something crazy was going on, like you had to raise a driveway 2 feet or something like that. And wow, there might be an appropriate exception to this design standard. Who decides if there should be an exception to a design standard?
the HPC could do that.
Okay, and who else could do it? Who else can grant a variance? I mean, that's what it is. It's a variance from something in our ordinance. Who would grant that variance?
This board.
That's this board. So when this board took all of the factors into consideration, the fact that the driveway was being raised, in order to get cars to existing parking in the rear, they had to go through the building anyway. So they're raising a driveway. In order to do that, they raised the building the minimum amount they possibly could, because they were going through the driveway anyway. There was already a hole in the building. And this board decides, assuming that you were right at the time, I may have falsely assumed at the time there was an actual standard that said you can't park under a historic structure. I see now that there really may not be one, but at the time I thought there was. And the idea was, when would you make an exception for that? Is this circumstance sufficient to make an exception? And this board talked about it, struggled over it, worried about the HPC's position, and made a decision that this is an appropriate extraordinary circumstance where parking is appropriate under a historic structure. Which board would actually have the final authority to make that decision? Us, correct?
Yeah, obviously.
Okay, and we did that. But in the concept of no good deed goes unpunished, because parking is a bit of a weird thing where it can, in fact, visual stuff. Parking in front yards, streetscape, design. We don't know how to make it as unobtrusive as possible. In an act of extraordinary concern for the HPC, this board said, we're going to send it back to them and tell them that we think you should be able to park under there. But you guys may have some expertise in how to make it unobtrusive or, analyze it in a way that we may not foresee, and then come back and say, okay, obviously the board that's going to decide an exception to our rules has decided that it should be an exception. What can we do to make this most compliant with the standards, meaning most unobtrusive? And now the position is, well, we did it, whatever your position is as you've stated. But it might be helpful for me when I draft the resolution on this, in case the applicant's successful. What's the HPC's view on how to make parking under the home as unobtrusive as possible? Are we supposed to put doors up? Was that, because I couldn't really tell from the resolution. The resolution doesn't say what happens if we allow the parking, and I think the board would benefit from your expertise on that.
Yeah, well, I'm getting a little confused. We're acting here as a Board of Appeals, so it's not a resolution that's coming up, it's an opinion that we have, right? Whether or not what the HPC did was arbitrary, capricious, contrary to law, that kind of thing. So we've already, the HPC, or the zoning board's already made our decision, okay? And that's what caused the issue here. It's a conflict. And what the HPC did was something contrary to what our board did. So how to resolve that? Okay, you appeal appealed that, and we want to see whether or not what you did was arbitrary, capricious, or contrary to law, and that's what we're going to do. We're going to have an opinion here, right? Not a resolution. Is that right? Correct me on this because I'm a little confused. Because dealing as a lawyer for 40 years, I know what appeals are, and I'm not sure that I understand that we are doing an actual appeal here or not.
Well, we're going to do the same thing we did a month ago. All decisions of a board are set forth in a resolution. That resolution will contain your opinion on
Okay.
whether the appeal is successful or not. So
Okay, you cleared that up. Thank you.
it's not mutually exclusive. We're required to pass a memorializing resolution by statute.
Okay.
And that's what we're going to do. I just, on the area of the board's expertise, I just think that it would be helpful to understand, since it's not in your resolution that we're reviewing, what design standards, what things do you think can be done in case we decide parking should be under the building? How should that be done in your view?
And I'll answer that. I just want to point something out with regard to interpretation of that page. The interpretation that parking beneath buildings is not permitted in the historic district is followed in every instance and has been followed in every instance, as indicated in the transcript. It has not been allowed under buildings. So as a matter of fact, and of course, that has been the interpretation, that section would also govern parking under the building, is to maintain the character of the district. But to your second point, what can be done? I was searching for, I believe it's part of your resolution, which indicated that there should be appropriate modifications or visual modifications to address the parking under the building. I would request, if it is the consensus of this board, to approve, to reverse what the HPC did with regard to not approving it, but to remand it for the purpose of the HPC applying their expertise to develop a solution to the minimizing the visual impact of that parking, which they can do. I certainly cannot do
I
that.
thought they had already once said something about a gate.
If I'm,
Rather than send them back for a third trip to the HPC, which would be their fifth hearing on this, isn't there something we can reinstate that was there before, that's in the record?
may I speak
about
to
a
that?
gate, please?
And I don't want to step on
Madam
Mr.
Chair, if you're
Feinberg's
interested
toes.
in that.
The transcript at page 35, and in fact, the pages that lead up to it, do talk about the gate, but they resulted in the condition that that lattice gate be removed from the plans. The comment of one board member, page 34, is, my question, are you suggesting we just remove the door? The response, well, it's going to go hand in hand with no parking under the building, because we don't want to see cars under the building. So if you put cars back under the building, put the gate back up, and that's
Thought that was the
unobtrusive.
clear implication. Do you want to consult with your client, Mr. Feinberg, on that before we passed it?
I think there was further discussion to say that if there is a gate, it should be a gate that automatically opens and closes, not relying on mechanical means, so it would be left open.
Yeah, that's fine, and that was discussion as part of the record at the HPC. Materials were already discussed at the HPC, so it's all there.
Okay. If I may take a few minutes, and I will have that discussion.
Sure.
So just want to bring up one other thing that we talked about at our meeting was this property in particular has been parking on this lawn for as long as I've lived in Cape May, as long as I've been here since 1978, and it's really been an eyesore. I really felt that this was a good solution. They have to park somewhere. You know, that was one of my big concerns, is all that parking on that lawn all the time.
It's appreciated. It really is
In
appreciated.
fact, there's a picture in part of the materials here which shows two cars parked on the lawn. So you're absolutely,
And Mr. Feinberg, I wrote the resolution, so I want to defend it just for a moment. The resolution went through great pains to show that this was an extraordinary circumstance. I don't think this board is of the opinion that parking should be under historic houses as a general concept. I think it's already has a hole in it, and there were specific reasons why the driveway was being raised and the house was being raised slightly, and it was an extraordinary situation. So I don't know that it's a fair assumption that this board has come to the conclusion that it's appropriate to have parking under historic homes. That's not what our resolution says. The board, your HPC shouldn't take it that way, and I certainly, when I drafted, I intend to express this board's opinion that I understood from the board, that they didn't believe that to be the case. So, in fact, we passed a specific ordinance indicating you can't raise a home for the purpose of putting parking under the home. So I just think this is an extraordinary situation, and we went through pains to make that clear.
Okay, thank you.
Before we adjourn to allow some consultation, I'm concerned with permitting any one member of the HPC, which only acts as a body, in this quick format, the potential to impose additional conditions or ask you to impose additional conditions because the HPC may only speak as a board.
Yeah, I think you're right. I don't think we can oppose additional constraints here because this is an appeal. We want to see whether or not what the HPC did was, was not arbitrary or capricious.
Yeah, but I think what we are allowed to do, okay, is to, we're hearing, we're gonna, if this is reversed, it can reinstate the prior resolution. And I thought that at one point there was no parking. If there was gonna be parking, they wanted a gate, isn't that right?
Yeah, and that's the second part of my comment, if you'll bear with me, which is, in addition to my concern about allowing any one member of the HPC to speak for it here, I don't think anyone does. Number two, I think our record really tells us what the answer is. I mean, we have the board fully convened.
Andrew, isn't there the possibility that they will talk to them, and then there could be some consent and you'll agree to do it, and then we can be past that issue? I mean, it's a sliding gate with an electronic mechanism. I mean, maybe the board will do it, no matter what you guys say, or maybe Mr. Murray will think that we can, or whatever might happen. But can't the two of you have a conversation for a moment, and then come back and say, if the board, as the applicant, volunteer to do anything, forget conditions, you can come back to the applicant and says, if the board is going to allow us parking underneath, we will install a mechanical gate, and we can certainly let you agree to that if you'd like, as opposed to us opposing it.
I will-
So can you guys have a conversation for 2 minutes about that, and then let us do it?
We can, but I'm going to tell you right now on the record, we have no problem with the reinstatement of the requirement of a gate and no problem with the condition that it be some sort of a mechanical or automatic gate.
I'm hoping that Mr. Feinberg says that
Okay. If I may have a couple minutes.
that would be great.
Okay, well, again, I'm a stickler for the statutes or the law in Cape May says specifically appeals from how they're to be handled. And I'm not so sure this is part of it, okay, but I'm not that much of a stickler that if it's going to,
Problem
put this
solving
thing
is
further.
always part
But
of
it
the
says here,
process.
is there an error that was made before? And it says it right here, and we're going to determine that here, whether or not, under the conditions of appeal.
And-
So the rest of the stuff, I'm not sure.
That's why they're going to go talk off the record, and problem solving is part of the process. And
We
the applicant
jointly,
can
you're
always-
saying, in other words, we're going to go try to mediate this?
Yeah, I just.
You're gonna try to mediate it
for
in
3
front of the-
minutes.
okay.
And then you come back and say, we've resolved the issue of the gate, and then we can just make a decision about parking.
My point is, I think it's already resolved.
I'm hoping it is. I'm hoping it's a 2-minute conversation.
I'm happy, if it makes this board more comfortable,
Or we can just decide the parking issue, and then there's a hole in the front of the building, and then I guess we go back to the HPC.
No, respectfully,
I understand. I don't know
The plan that
what's
we
going on.
approved had a gate on it.
What's that?
The plan we had approved had a gate on it.
Yeah,
It did.
right.
And we have no objection to this board modifying the HPC's approval to remove those two conditions. Like I said, we only appealed one because it was the main event, frankly. But if this board removes both of those conditions so that parking goes under the building and the gate goes back on, that is satisfactory to us, and it's consistent with the record of the full HPC.
So you're asking us just to reinstate the original resolution, which had the parking allowed and the lattice doors, gates?
This board's.
Yes, this,
Our resolution.
our resolution,
Yes,
yes.
yeah. there
You're
were two
asking
other-
us,
Yes.
okay.
Yeah.
But Mr. Feinberg asked for a remand so they could consider other potential solutions, And I'm hoping that they don't really want that after they speak to each other, and, or we can just go back to our resolution. I thought there was something that let us do it if they didn't agree.
Mr. Copeland is here. I'd like to
This
get
reminds
his
me,
input.
you argue before the Third Circuit, and you say, well, excuse me, hold it, maybe we can mediate this before.
It
That's not
happens.
the way it's done.
I can't tell, Mr. Amenhauser over there smiling laughing, it's exactly how it's done. They say, gentlemen, step in the chambers, and then you go back and you work it out, and then you come back and you stop arguing about it. That's what I'm hoping goes on, because ultimately, the HPC does have insight, so maybe they come up with something that's really great, or we just do what we said we were gonna do.
Mr. King-
It doesn't matter to me. If the board wants to continue, you can vote and can just press forward.
They cannot come up with anything here because they are not here.
I understand, but maybe they'll have a brilliant idea that you can send to, I don't know, he wants a remand for it, so can't you just? All right,
I'm
fine.
happy, if the board wants me to take a moment and speak with Mr. Feinberg and a representative of the HPC, I'll step
My
out.
mistake was envisioning him leaning back and saying, the electronic gate's okay, right? And him saying, yeah, that's fine. And
That's what-
then we reinstate our prior decision, we're comfortable that everybody's happy, and then we move on. That's what I was hoping was gonna happen, but we spent more time arguing about whether he can ask us a line of questioning than doing
We're
it.
having them bounce back to them.
Can we just, can you ask him to,
If we want to adjourn for that purpose, that's fine. Here's my point. I don't want to come back and have a request for something that comes out of the blue with no basis
the
and no
board's ultimately
authority.
gonna do what the board wants to do.
Okay, thank you.
Well, I'm suggesting that we stick with the appeal as it was
Okay.
before, and if you want to talk about in the meeting, you want to take a break from that, or, but we're here to hear an appeal in accordance with the code in the city of Cape May.
Mr. Farmer, go ahead, finish your argument, and then we'll wrap up.
Finish my argument?
Go ahead, yeah.
Yeah.
Okay. I may be finished. I think to repeat myself is not productive here. I'll rely on the arguments that I made already. I think the goal is to preserve this property in accordance with all the other properties and the standards that have been applied to those properties, and that can best be done by finding an alternate solution to the parking underneath the house. But I do renew my request that if this is reversed, that the HPC be given an opportunity to consider alternatives. I guess the end result, the last decision you can make is to go back to your resolution and require a gate that's automatically operated.
Well, I just want to make sure, Mr. Hurlis, that is part of the initial,
That was on the plan that we considered.
that's what I thought.
I'm gonna,
It was on the plan, I don't remember putting it in the resolution, I'm taking Craig's word, it was in the plan, that's not my ballot. The plan's incorporated in the resolution, so technically it's in there, I'm just saying that I don't remember us making a decision that the electric gate was the way to do it. The hope was that the HPC would address that while it was back down there, but.
Well, and I'll share with you so that we don't spend more time than we have to. It's my recollection as well. Number one, we know the plans that this board approved showed that gate. But I don't recall any discussion here about that being an automatic gate. But if that satisfies the HPC, we're okay with that. So we are making a modification in response to this.
No,
no, it was on.
all right, well, the plans are incorporated in the resolution, so we'll go with that.
I'm not sure if Mr. Feinberg was done. I wanted to very briefly respond on just a couple of
Madam
items.
Chair.
Sure, rebuttal, sure.
Thank you.
Further argument.
You want further argument?
He wants to respond to Mr.
Just on a couple things, and I will be very, very quick. And really, it's, Mr. Murray, you indicated that the question to be decided is it arbitrary, capricious, or unreasonable, or contrary to law? I also think there's the jurisdictional question. Number two, a remand, the request for a remand. I can think of no more terrible thing to do to these poor folks at this point. The whole point of the procedure that I explained and the relative jurisdiction of the boards is to not place folks on a hamster wheel getting bounced from board to board. If they get remanded back to the HPC and get another decision, then they're appealing back to this board again. You're here. If the HPC wants to be heard, it should exercise its role in its advisory function and speak to this board when it makes its decision, because when you speak on something, it is decided, it is cast in stone. All that's left are those aspects of the project not determined by this board. We just simply request the removal, the excision of those two conditions of the approval, and we very much appreciate your time.
Okay, I'm not sure that we have the power to remand anything. I'm looking again at the code, okay, and it specifically says about appeals. We make a determination on an error here, and I'm not sure that we have the power to say remand this back to the HBC. I don't know. Rich, maybe you can address that, but that's not what I read in the code. So it seems to me that the issue is, you know, what we can do is decide whether or not there's been an error and whether or not we can go with it or against it. So that's what my understanding is, and correct me if I'm wrong.
I think because the board can always seek an advisory opinion from the HPC, they can remand it for further information if they want to. But if the board decides to remand it, I'll address that in more detail, but I don't know that that's, I don't want to make a tough decision that I don't have to make. So I'll give you, I guess I'm supposed to give you the benefit of my legal opinion, so I'll give it to you. On the jurisdictional issue, Mr. Katniss is both right and wrong, in my opinion. He's right that on things that we decide, that's it. Okay? In this instance, because parking is a weird thing. We've had this before. We had it on Eldridge, or what's that road? The road that goes out to West Cape May, near the Atlantic. thing.
Elmira.
Where, Elmira, thank you, where a car was gonna back out into the road, and the HPC didn't want the parking in the side, and we felt it should, and Craig was worried they would have to back out at an angle. And ultimately, I said, parking is our decision. It goes to ingress and egress, the driveway, and that was our decision, and it didn't matter which HPC, that we had the ultimate authority over parking. If the HPC thought that 3 spots was too many, but the RSIS required 3 spots, that's our purview, that's our decision. That's what we do, although the other instance, it may have been the planning board. But in this instance, because the parking issue wasn't so much a typical parking, it was what size of the space, ingress and egress, it had to do with the aesthetics of the parking, and aesthetics is sort of like an HPC consideration. This board, out of respect for the HPC, to my recollection, sent it back to the HPC so that they could work out if they saw things the way we saw them, and if so, how that should be done best. And we sent it back. I don't know that we had to send it back to the HPC, but we did. So arguably, Mr. Katniss is right. If we had decided everything, then that's it. And that's our jurisdiction, and that's what we do. And we can grant a variance for things, we do all that. But in this instance, we declined to exercise exclusive jurisdiction on that issue, and we sent it back to the HPC to deal with the parking issue. And they did, and now it's back here. So the system sort of worked. So Mr. Katniss, that's why I respectfully think that you're both right and wrong. We gave them the right to touch this parking issue in this instance, because it had so much to do with aesthetics. Now, so on the jurisdiction issue, I do think the jurisdiction issue has been handled properly. Now the question is whether the board acted arbitrary, capricious, and unreasonable. And this board has set forth in a long resolution its opinion on this issue. The HPC has issued their reasons for requiring or prohibiting the parking underneath. They've discussed with you the design standards that they think were the basis for their decision. And you need to decide whether their decision was unreasonable.
Whether theirs, not our board. We're not talking about our board.
I think our board would conclude, hopefully our board wouldn't think that they did something unreasonable.
that's not-
But what we're
Right,
doing is we're
that's not the
deciding
issue
if,
here.
we're
It's their
deciding
board.
if the HPC's decision was arbitrary, reasonable. arbitrary, unreasonable, or capricious, whatever that exact language, I'll read the exact
Well, that's
language.
exactly what it says, and,
I wrote it, so.
yeah, and what we're talking, this is the code, the city code. And what we're saying here, that there was a certificate of appropriateness issued by the HPC. And in that certificate, which is part of the record here, it says that everything is granted other than proposed underground parking, which means they could not have done that, okay, because of this certificate of appropriateness. So the appeal here says the determination of the HPC may be overturned only if the Zoning Board of Adjustment, our board, finds that the HPC determination, which was in the certificate of appropriation, was arbitrary, capricious, unreasonable, or contrary to law. That's my understanding of what we are deciding here today as this appeal. If you have any difference of opinion, please, you're entitled as attorneys to bring it up.
No,
Okay.
that, and, I mean, you've heard on the jurisdictional issue, I still think it's before the board.
Okay, yeah,
the
I didn't
jurisdictional.
focus on that, you brought that up.
Got it.
Okay.
Anybody else have any questions?
I have a question. In this case, do we open to the public?
We're not taking testimony.
Okay, I just wanted to ask, because I see a lot of people here.
I'm going to say no with one caveat. It's an appeal on the record. I don't know that means public can't participate. It would just mean that it would have to be a legal argument. So if there was an objector who wanted to make a legal argument, I'm just saying in other cases, I'd have to really give that some thought, because we have, but I don't think anyone participated below, so I think they'd be introducing new argument, but I think it should be limited to the record and the arguments of counsel who participated
To
in the
me,
hearing.
that would be highly unusual in an appeal to bring in some amicus at the last minute, sitting there in the audience to raise objections
Okay,
or to
well,
bring a point. That's just my own personal opinion based upon my experience. I think that would be very unusual.
I'll elaborate on my opinion on that then.
Okay.
If an objector had appeared at the hearing and argued for or against this, they hired an attorney, he appealed that there was no jurisdiction, let's say, and now they come before this board, and that same objector wanted to make those arguments again at this board, my opinion would be, I would let them. They argued it down below. They're a member of the public who has an interest. People intervene in cases all the time.
Yeah, but they don't just show up.
Well, we're not handling motions. So I'm not aware of any attorney who's representing the objector who wants to argue, so we can just move past that. We have 2 more applications, so. Is there any attorney who appeared below who wants to offer legal argument? Or a member of the public who offered argument below on a legal issue? You're represented by counsel already. Anybody else? Okay.
Yeah, I don't think that's
No,
appropriate.
that's not appropriate. No. You have counsel who's articulated, you participated in the hearing below factually. No.
You're one member, not the board.
Sir, first of all, stop. If you're going to speak into a microphone, and let me, I'll hear why.
Respectfully,
I have
object,
to,
no,
he
no,
has to be
no,
able to say why he thinks he should speak.
respectfully, I'd like to be heard on my objection.
Yes.
Of course.
Yes.
I let everybody talk.
We have an individual.
Well, I'm going to let him say why he wants to talk. I have to hear why he wants to talk. Then you could object to why he wants to talk, but if he wants to tell us, let him say why he wants to speak. He's not going to say anything substantive.
Mr. King, we have a member of the board from which the appeal was taken who is represented here by counsel on a closed record.
Right.
I have no idea what will come out of this potential witness's mouth right now.
Neither do I.
And what I do know is that the record is closed,
Correct.
and I know that the board that this person is a member of is represented here.
Andrew,
This is respectfully note my
Mr.
objection.
Catanese, I agree with you, but here is a lesson. I mean, unfortunately, I'm stuck being almost like a judge here, and what I'm saying is, I can't say his request is wrong if I don't listen to his request. So he's going to say, I would like to speak for this reason, and I'm going to listen to that, and then I'm going to say whether I think that's an appropriate thing to talk about. But if I don't let him say why he wants to talk, for all I know, he could say, we fired Mr. Feinberg last night and he shouldn't be speaking here today. And then, oh my God, what do I do? So I got to hear why he wants to talk, and then can say it's inappropriate for him to do that, but until I hear him say that into a microphone, I can't do that.
Let me make sure that we understand what's going on here. We are the zoning board. We have a chair that's sitting over the chairwoman. The decisions will be made by the chair.
Absolutely.
And council is great. We have a wonderful council here. But we are a board here, okay? And we operate under certain rules and regulations. So it's up to the chair to decide whether or not. But my recommendation is not to let somebody testify before an appellate board, which is what we're acting as here.
No one's allowed him to testify
Okay,
yet.
but it's up to our chairperson.
He believes he should be heard, Madam Chair. I believe you should
wanna
hear
know
why
what
he
the
believes he
reason
should be
is.
heard.
Right.
And then you can decide if that's a reason you want to hear or not. But until you hear the reason why he thinks he should be heard, you should hear it. So you have to let him say why he thinks he should be heard, in my opinion. You can say, no.
Record will please reflect my objection.
Yep.
Thank you.
Why do you believe you need to be heard with counsel here?
Well, first, I'm
And
warned,
it's like a sentence.
there is an ordinance that has been overlooked by this commission.
Is your microphone on? I can't.
Excuse me?
Yes, it is.
Your microphone.
Yes, the mic is on.
I please note my objection. I don't want any further discussion on an ordinance that's potentially been overlooked.
That's not it.
There is counsel.
I know.
I don't want to,
Are you speaking as a member of the public?
I am speaking as a member of the
Do you
public.
think you should be allowed to speak as a member of the public?
Yes, I do.
On this topic?
Yes.
Okay, Madam Chair, do you think you should be allowed to speak or not?
No.
Okay, that's it. Thank you.
So I'm not a member of the public.
No, he's,
Well, it's not.
You're not
you don't-
interested in the truth. You're not interested in another ordinance. An ordinance there is,
sir, don't do that. That's rude. You know you can't.
what you're doing is rude
The
and
chairman has
inappropriate.
decided that you can't speak. You have an attorney. If there was argument to be made, you should have told him that, and he could have made it. And I think he did make it, as a matter of fact, because he's very good at it. So if there was an ordinance, if there was a, sir, don't do that.
There's an
Sir-
ordinance.
sir,
Why
sir,
did you want to hear
Sir,
an ordinance?
you have counsel here. If there's an ordinance that you wanted the council to speak about, you could have spoken.
As a member of the public.
No, that's not how it works.
Well, now, am I a member of the public or not?
No, you're a chairman of the HPC. You're chairman of the HPC.
No,
If
your
you have-
position is clear. I'm a taxpayer, but not a member of
Do
the
you want me to
public.
explain it to you? I'll explain to you how it works.
No,
Do you want me to or not?
Want me to
Are you-
explain to
are
you
you
the ordinance?
I'm gonna
that
explain, don't do
specifically
that. Sir, that's
prohibits
rude.
parking under the house?
Sir, you're doing it wrong, okay? If a person who holds a, you're not, well, I'm gonna say it on the record anyway. A person who holds a position with the city is a member of the public, but their ability to speak on that has to relate to the direct impact on them. And they can't purport to have higher standing, either knowledge-wise or persuasiveness as a result of their position. Just as a member of the zoning board who's conflicted, can speak about an impact on their own home, but they can't explain that they have higher knowledge of what the board would otherwise do. So a member of the public can always speak, and that gentleman could speak if this house was next to him. But as a member of the HPC, as the chairman of the HPC, represented by counsel on a closed appeal record, it's inappropriate for him to provide additional argument in addition to that which his attorney could have spoken about. That's why my Madam Chair gave the answer she gave. If I'm misunderstanding her position, she can state it.
No, that was correct.
And again,
Murray?
please let me get back to the code again, all right? That's what us lawyers do. We look at the code, okay? It specifically says, the appeal shall be heard on the record made before the HPC. That's very clear, okay? That means that people can't go up at the last minute and testify. There's a record, we looked at, we got copies of it, we all read it, okay? That's what we're gonna base our opinion on, okay? And it seems clear to me, I don't know if it's not clear to anybody else, but that's the way they're always done appeals. But again, it's part of our city code here, specifically says that, made on the record. That means no testimony, okay? I think we all understand that, no testimony,
I
and
don't
that was
ever
it.
remember anybody
Okay?
testifying.
And Madam Chair reflected that, thank you, okay?
That's his speech an
If I
hour.
may, I understand the emotions here. He was referring to the transcript, and the transcript talks about the flood mitigation ordinance. That's what he wanted to stress. That is in the transcript, it is part of the record, that the flood mitigation ordinance prohibits activity underneath the house. That's what he wanted to stress.
That's what you do as counsel.
You know that.
Can I ask you another question, though? Why did you approve, why is it okay to have parking under the back?
Yeah, Madam Chair,
That makes no sense.
Because that's not being raised.
Yes, it is. It's being raised.
The back unit?
The back is going on.
I can answer things I want to make, comment, and I'm happy to answer your question. Number one, the flood mitigation ordinance does not say that you cannot park under a building. It does not, and I think you're already on that, but we just heard it was limits what you could do under a building. No, it doesn't. To your question, the rear building was proposed to stay at its existing elevation with the first floor converted from living space to parking. It was just the front building that was going to go higher to accommodate that driveway. But the rear building was converted, the first floor, the ground level of the rear building was converted from living space to parking under the
So
building,
it's under the building.
and fully exposed there. There's no enclosure. Of course, it's
Yeah,
in the back.
Nobody can see it. But still under the building, which seems to be the whole point of this. Okay. Mr. King?
Further argument, counsel?
You know, if it's not going to be remanded, and I appreciate your comment, then I again would request, if you go back to the plan, which is part of the record, that does provide for gate, that you stipulate clearly that that gate is to be operated automatically and not manually. Otherwise, we're going to have something I think that you don't wish to see either, and that is an open gate all the time. People just are simply not going to mechanically close it and open it. If it opens automatically because a car comes or goes, then that problem is solved. Then it truly would be as unobtrusive as possible.
I'd ask the board to note that the applicant has indicated they don't have an objection to it.
Yeah. You made that part of the record, right, of this appeal?
Correct.
Okay. Okay, we ready to call the question here?
I'm ready.
Me too.
Go ahead, Mr. Murray, make your motion.
Okay, we are here to make a decision based upon this appeal, okay? And again, we've heard argument from both counsel for HPC and counsel for the applicant, okay? And we read the record, we've got transcripts of the record, and we already have that. We're familiar with what went on below. So now we have to make a decision. Was the decision that was made by the HPC to insist there be no parking under the house, was that decision made, was it arbitrary, capricious, unreasonable, or contrary to law? Now, my position is, again, I know Mr. King differs with me, but it was in the transcript. There was the question raised, okay, by Mr. Catanese at the transcript below, okay. I understand there was a house down the block that was raised, has parking underneath, okay. That statement was not rebutted by the HPC. Nobody came up and said, no, that's not true. So we don't know. All we know is what's on the record, what he said. And I think that we can presume, since there wasn't a response, that it's true. And if it is true, then to have it on one house and not have it on the other house, to me, seems arbitrary, okay? So I would vote in favor of finding that the HPC requirement was erroneous because it was arbitrary. That's just me, okay? Everybody else is entitled to say your
That's not a
pieces.
motion.
Okay.
Okay, does anybody else have any other thoughts they'd like to share on the reasons why they think it is or is not arbitrary, capricious, unreasonable, or contrary to law?
I don't think, I think we need to follow what HPC does. I think they really looked to see what was happening in the city, and we keep overturning every time they make a decision. Then we need to support each other, and we need to follow what's going on. This is a Victorian town. This place is, getting a lot more building, and then things are changing. And I don't believe that we should allow the parking underneath, but that's my own personal opinion.
So I agree with you in supporting our HPC colleagues, but I think in this instance, in knowing that there is available space, that perhaps a design aesthetic could be applied in which this would be, unobstructed. The issue of the to and fro is going to occur anyway because of the 4 cars being parked in the back. I think it's contingent upon the owners to make sure that that gate is installed and any other landscaping that could be applied. and done so in a way that has them not parking on the lawn, as Ms. Hutchinson has said, that they would be going in there to drop off things. There will be some type of flow of traffic. So for that reason, although I agree with supporting our colleagues, I think there is a means and a manner in this instance to sort of find a middle ground.
I think we all differ, but I just don't think that we should just look at all these things that are being put down by the HPC are very, they're very educated people, and they're really looking at all, I don't think they did it, to be arbitrarily. I think they were looking at the best interest of the neighborhood and the building. And I know parking is an issue in Cape May, but that's something else we have to address, not with this one building. And I still believe that they should not have the parking underneath. But if you have been down there and see the house is being totally demolished right now, there's very little bit of that house that's left. So, I just want to make sure that they follow through what they're going to do, because I'm watching that every day, how much of that building has been taken off. And it's, I like to see that it gets put back the right way, but I still don't agree with the parking.
It was well said, Mary. I agree with you. I don't think this decision should reflect in any way, shape, or form a adverse position with the HPC. They do a marvelous job in this
Right.
city. They are very, very talented on that board, okay? They're represented by fine counsel on the board and everything. But this is a specific instance that we talked about before. And when you look at it and you say to yourself, well, how do we resolve, we have a parking issue here. That's our jurisdiction.
Right.
Okay, we have a parking issue here. How do we resolve that, okay? Well, one of the ways they resolved it was they did away with the curb cuts. And that means people can't park on the front lawn. Where are they going to park? Okay? It so happens that there was unobtrusive space under the house, is the way we looked at it, and that's where they parked on there. This specific incident, as Mr.
And they
King
had to go through
brought
the house
out,
anyway.
he brought out in the resolution too, it doesn't set a precedent at all, okay? It doesn't mean that we don't like the HPC, again, I think we all do like it. They just serve, they're a wonderful function here. But on this specific issue here, I just think they made an error, myself, okay? And so that's, I just want to make
Right.
sure that, that's out in the public, that we're not against the HPC.
Right.
This was if I may, and I don't vote, you know that I don't
That's
vote.
okay.
But this is a unique one.
Yeah.
Because this is something that I believe that the applicant brought before us and said, listen, the HPC is concerned about parking underneath the structure. And we asked a lot of questions of the applicants when they were before us. I remember asking them, well, and there is a provision in the ordinance that says you can't raise the structure higher than the base flood elevation to accommodate parking. So we asked a lot of questions. This is not driving the elevation of the first floor, right? Remember, we went through that. We were very concerned. We're trying to back up the Historic Preservation Commission in that case. This is a unique situation where the house is essentially the whole width of the lot. There's no way to get around to access the parking that already exists in the rear without going through the structure. So there's already a driveway going through the bottom of the structure. So as part of our deliberation, this use required 14 parking spaces. They only had 4 on site. They had a 10-space deficiency. One of our master plan things, I mean, it's emphasized in our master plan, says we need parking in the city. This board took the opportunity and said, listen, it's enclosed, it's not in the front yard, there's already parking occurring on the front yard of this structure, of this site. We're gonna try and fix that by providing 4 parking spaces underneath the structure that's hidden, that's screened. Let's send that recommendation back with the applicant when they appear to get their final HPC approval. And apparently they didn't find that was, so we tried to work with the HPC, and there was a lot of, it got heated tonight.
But the
And I just want to make sure that everyone is
Right.
aware of what this board did.
And they were rightfully concerned with the streetscape, okay? That's what the HPC, they don't want cars parked in the front. And that's what we considered, we considered their consideration. Because that's their purview, the streetscape is their purview, what it looks like from
Yeah,
the
we
street.
took a lot of time, really.
Yes.
Yeah,
Consider.
okay.
And
I'm
on
done.
the ordinance that we alleged, that we were ignoring, denying the constitutional right, that ordinance, if you may recall, I worked with the chairman of the HPC to rewrite it to make that ordinance stronger. And that's why we specifically discussed it at the hearing in the resolution. I rewrote it to make it stronger than his original version that he gave to me. Because we agreed with it and we felt strongly about it. Right, Craig, do you remember that?
Yes.
I don't know if it was, so, it's not that we ignored it, we knew about it. I wrote it to make it stronger, and then we considered it, and we're worried about it, and dealt with it as best we could in that hearing, and this board really went out of its way to do that. So if you could relay that to the chairman, it wasn't overlooked, and perhaps remind him that I helped him write it. So if we could, if someone can make a formal motion, we can perhaps get to the
So moved.
next application. The motion, I think, is, the motion is to affirm that this, wait. I think we should do it as a reverse. I think it's a motion to reverse the decision of the HPC as arbitrary and capricious and impose to reinstate the provision of the plan that requires a gate, and we're clarifying that it's to be an electronic automatic gate. I think that's the motion. So if you vote yes on this, that means that there's going to be parking under the building with an electronic gate. If you vote no, that means there will be no parking under the building, okay? Yes is parking with a gate, no is no parking. Everybody
Mr. King,
understand
can
that?
I make one
Yes, ma'am.
clarification?
Yes.
That it's 8 parking cars parked, no more.
I think it's 4.
Well, 4 in the back.
4 in the back.
And 4 there. We don't want to have double stacking just because it's.
Yes.
So I
And
just want
I
to
think
clarify that it
that-
will only be 8.
That's
per
great,
minute.
and
Okay.
I think just to clarify that all the provisions of our prior resolution are incorporated in this decision. So that concern and other conditions and all the other stuff will be part of whatever motion was just made, okay? So that's the motion I recommend being made.
Good motion. I will make that motion.
Okay, is it seconded?
Second.
Motion by Mr. Murray, seconded by Mr. Ledwin. Mr. Ledwin.
Aye.
Oh, yes?
Yes.
Yes, I'm sorry. My apologies. Mrs. Notch.
No.
Mr. Walsh.
Yes.
Mrs. McDade.
Yes.
Mr. Venuto.
Yes.
Mr. Murray.
Yes.
Mrs. Hutchinson.
Yes.
Thank you.
And just again, to make sure the record's clear, this is not precedential. I don't think it is. This is, can't be served as something that, we'll talk about in the future again for underground parking.
Can I ask a quick,
Maybe presidential as much to the extent that we don't want underground parking. It's
Yeah.
really extraordinary to under building parking to ever get it.
These
So,
circumstances.
well argued, counsel, thank you.
quick
Thank you all.
question for
Thank
the
you all
board?
for your time. We appreciate
Quick
it.
question for the members of the board? We can't get back on this hamster wheel again, like you said, right? Like, they can't come back again, and, because this is pretty
We
terrible.
didn't send anyone, we decided. We didn't remand, we didn't.
The UN done, right? It's done. You're not coming back before our board, right?
We are not coming back before this board. This is, at least not in any foreseeable, not as part of the development of this project.
Unfortunately, we can't legally hold you to that.
Revised plans
It's nice if you
show
don't.
the gate on it as compliance plans.
I'm sorry.
So get revised plans, compliance plans that show the gate.
Correct. And the parking, yeah, we had taken the cars off.
Yes, the parking information.
Great, thank you all.
Short break.
Yeah. We take a 2-minute recess. Just stand up a minute.
Okay, so I cannot stop the streaming. So anyone that has their mic on, you are being live streamed. So you may want to turn off your microphones. Thank you.
Tim, turn the microphone.
No,
Rich, I also want to see you and Bob together a second.
Microphone's on.
Great. Our next application is Mr. and Mrs. Knoll at 1303 New Jersey Avenue.
Right. Okay.
All right.
You might want to turn your mics
You
on.
can turn your microphones back on.
Perfect.
Can everybody turn your microphones back on, please?
All right. Ready?
Okay.
Okay. Good evening. My name's Thomas D. Keywood. I'm an attorney. I represent the Knowles. Mr. and Mrs. Knoll are over to the far left. I do have Mr. Farnan. He's our professional here. He's the architect. This is a project at Block 1147, Lot 37. It's a undersized lot with a non-conforming structure on a non-conforming lot at 1303 New Jersey Avenue in the city of Cape May. I'd like to be able to put them under oath.
Absolutely. If the three of you could please raise your right hands, and we'll also swear in our board engineer. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, and I know we are here for multiple variances, and I think, you know, a lot of them, again, this is an existing non-conforming lot. There's a lot of stuff that we can't do stuff with, but I think the biggest issue here is the use variance that was triggered by the floor area ratio. In this case, it's 3%. I know you're probably tired of hearing lawyers, so I'm going to let Mr. Farnan kind of go through the process that he came to in designing this house. And I know I wanted to put the Knowles under oath just because I know there's some questions about the use of that house. And what I'm trying to say to the board and to the public, that the change of use on this house is not going to change. It's a single-family house. It gets rented out in August for about 3 or 4 times. They market it for 10 persons. They don't plan on changing that market with more than 10 persons because their kitchen and their living room can't really support anything more than that, even though they're adding, you know, they're adding bedrooms to this property. So I'm going to let Mr. Farnan go through his process of how he came up with the design and what he, I'll let him talk.
Sorry.
Good evening.
Speak loud.
Right here. And good evening, board members, Mr. Hurlis, Mr. King, Ms. Keenan as well. So I would like to try to be concise and succinct about what the plan is here. Ultimately, what the Knowles want to do is add 2 bedrooms and a full bathroom. As Mr. Keywood stated earlier, the existing house is non-conforming such that it extends into the front yard setback and both side yard setbacks. The side yard setbacks minimally compared to the front yard setback. The objective with this proposal is to situate the new spaces, the 2 bedrooms and the 1 full bathroom, on the 2nd floor. Where we're locating, what the proposed design locates those spaces, is at the rear of the property, directly above what is already a 1-story portion of the house. So as a result, we're exacerbating the nonconformities of the side yard setbacks. We're not expanding them horizontally in plan, but in elevation upwards. So that's where the side yard setback variance is required. From the use variance, which Mr. Keywood also touched on, that comes into play as a result of the proposed project being 3% in excess of the permitted floor area ratio. So what is permitted is 40%, what is proposed is 43%. That is equivalent to 150 square feet, approximately one of the bedroom sizes. So subtracting that 150%, or I'm sorry, 150 square feet, that 3%, would effectively mean cutting out one of the 2 bedrooms that they're seeking to add. We looked at different configurations in plan and in section to see how we could accommodate what their goals were. But from a constructability standpoint, it's easier to just build the 2nd floor directly over what is already existing We're not encroaching further on either neighbor. And if we were to try to build towards the back, we would come into a conflict with an existing detached garage building that's there. Obviously, building back wouldn't address the floor area ratio component. We would still be adding gross square footage. So that's just from a standpoint of the setbacks. Ultimately, it's my opinion, and I know that it will ultimately be the board's decision, that what we're trying to accomplish with this proposed second floor volume over what is a first floor would not have any substantial detriment to the public. Do not believe that it would inhibit light, air, open space, and be a detriment to the neighbors. Nor do I think there's any substantial impairment to the zoning ordinance that's in place already. Overall, I think that it's really promoting the design, the visual environment, because aside from adding this volume, the entirety of the house is getting a renovation exterior, which has been approved by the HPC pending the decision of this board. So I think that is all that I can offer off the cuff right here, but certainly open to questions and comments, and would like to engage in that conversation with each one of you.
Additionally, if I may, Madam Chairperson, in regards to Mr. and Mrs. Knoll, I'd just like to have maybe a few words from them. I know that they, they've owned this property for some time. Again, they only rent it during August, so I think that testimony would be important for the board in making their decision. I think the fact of the size of the parties that they rent to, I think, would be important. So I'd like to hear from Mr. Knoll on that.
But before we jump to the
Go ahead.
applicants, Mr. Farnan, do you believe that the site can accommodate the problems associated with the excessive floor area ratio as proposed?
In another design
No,
scheme?
in what you're proposing, can the site accommodate the extra floor area ratio that you're requesting?
I believe so, yes.
Can you articulate why?
I believe so because presently, as constructed, the existing space that is on the ground floor is more or less we're adding a second floor, but the space that exists in the rear yard, in the rear property, I think is ample in the context of the other lots that exist on that block. So I do believe that in the context of the neighboring properties, it does have that space to accommodate the new volume on that second floor level.
Mr. King, may I interject? Mr. Farnan, if, in your opinion, when you looked at this and you designed this and you met with Mr. and Mrs. Knoll, and they told you how often it's rented, the parties that it's rented to, would the use of that building be any different than the use of it is right now?
No, it would not be. And I would touch on another component, which obviously with the increase of bedrooms, there's an increase in parking requirement. In this case, 3 parking spaces are required. What is provided is enough room for 5 parking spaces. And that does not include the detached garage. So the driveway that runs effectively the length of the property until you reach the detached garage is enough such that it accommodates 5 parking spaces presently.
Craig, can you help me with that? Your chart says 3 and 3. Can you just explain?
Yeah, so I just used 3 because it's conforming, but you can see on the graphic on their sheet, they show 1, 2, 3, 4, 5, plus an existing garage. So the driveway can accommodate more vehicles than 3, but they're only required to have 3, so they do provide adequate parking.
Does the 2 bedrooms that are being added increase the parking requirement?
Yes. So the parking requirement as exists is 2 parking spaces. When you get to the 5th bedroom, it takes you up to a 3rd required parking spaces in accordance with the residential site improvement standards.
Can you just take a look at that? Yeah, picture? Is it, did I give you the right one?
Yeah, so 6 bedrooms, 3 required parking spaces. There's 3 existing and 3 proposed. You could, according with his graphic, you could show 5 existing, 5 proposed. Based on his layout.
I'm just saying, I want to write down, there's 2 more bedrooms require additional parking. The answer is yes, but they
Yes.
have it.
Yes.
That's,
Yes,
okay,
that's
do you
the
understand that? Okay.
So 2 bedrooms.
Everyone I must have been the last one to understand it. I'm sorry, I was looking around, I understood. Okay, so,
The threshold at the 5th bedroom, you need 3 parking spaces.
so the new 2 bedrooms requires an additional space, but they have it. Okay.
Mr. King, did you have additional questions for Mr. Farnan?
No, I'm just careful about the chart because I take this chart and I put it in the resolution, so I just need to make sure that it's exactly the way Craig wants it. Sometimes.
Thank you, Mr.
But I think it is the way he wants it, so that's fine.
So, Mr. Knoll, I know we were just talking about, could you talk a little bit about the use that you use the property for now?
Yeah, sure. I'll tell you a little story. We bought this place in 2015, and at that time, our oldest son lived in San Francisco. Well, about a year ago, he decided to move back home and get married. Well, so that started us thinking about this, because with him coming back, we could not get our whole family in that house the way it existed. So we started talking about finishing off the 2nd floor to provide space so that we could have the whole family. And that's really what our motivation is. I'm not interested in generating more revenue or rental income or anything like that. It really came down to us trying to accommodate the family on family vacations. So I don't know if that's relevant or not, but that's what our true motivation was for doing this.
And kind of on that same thought process, you did meet with Mr. Farnan, and you did try to get that floor area ratio down to the 40%. What happened with that?
Well, I think it cost something like 150 square feet in the overall plan, and we looked at 1 or 2 options that would be within the 40%, and it either made the outside of the house look odd in the back, or it shortened the house so that you had another drop-off in the rear over top of the 1st floor. And the inside dimensions, well, they became smaller, more difficult to accommodate the furniture that we wanted to put in and so on. But I think most of all, the outside of the house, it just looked odd.
And when you're talking about the outside of the house, there's other houses that are around you, and those houses are a little larger than your house. Is that correct?
Yes, there's one right to the right of us, right next door. I don't know when that renovation took place years ago, but I think that house, they tell me that house was basically the same as mine, built on the same foundation and the same non-conforming lot, but it is much larger than what I have now and what I will have if we put these rooms on.
That house that you're saying, and I heard you say to the right of you, is that actually to the left?
Well,
if you're looking at your house?
If we're standing on the street, it'd be to the left. It'd be the corner
It's
of
the house on the
Trenton
corner? The house on the corner?
House on the.
Yeah.
So the design that Mr. Farnan came up with, when that design was done, would it look more like the neighboring houses that are around it?
Well, when we get the outside siding that we want to replace, and I think it will look very much, it'll fit, actually, I think it'll fit in better with some of the houses across the street, to the left, and to the right for that.
So it's not going to stand out from what's in the neighborhood now? It's going to blend in?
Yeah, it'll blend in, sure. Right.
All right. In regards to, I know there was one point, I think, you're changing a solid wall into like railings, right? Is that correct?
Yes, on the front of the property, there is a second floor balcony that right now has, it's about 2 foot high. No, it's more than that, maybe like 3 foot high. And it's of some kind of solid construction. I'm not sure what the material is, but we wanted to spruce that up a little bit and use more of a porch rail type of structure to pen in that upper floor.
Mr. Farnan, would you like to talk about any of the, that portions of the property?
Sure, so, as Mr. Knoll mentioned, and as I previously stated, part of this larger project is re-siding, renovating the exterior of the house, and that is to enhance and promote greater visual environment. From the streetscape, the railing, as Mr. Knoll was just saying, is more of just a low wall that encloses that balcony. The intent is to provide a porch rail that makes it consistent with the architecture in the neighborhood and in the city overall. Touching on the adjacent, touching on the adjacent property, and I know it may be irrelevant to the board's decision. There may be no precedent that we refer to. This application is determined on its own merit. We understand that. I would just state that in the context, from volume and massing perspective, this structure would still be not as large, not as massive as some of the other properties that are adjacent, on adjacent properties.
I have a question. I was looking at it, and I looked at the front of the house, what you're doing there, it looks very nice, okay? My question is, are you adding siding, or is that just a depiction on your drawings?
The siding.
It looks like there's no siding
Right.
depicted here.
It's kind of a way that we, that's kind of just how we draft things, sometimes for existing conditions. If there's existing and it's entirely to be replaced, we don't show it. We kind of enhance the drawing with the character of what's proposed. Yeah.
Will you be siding the garage also?
I'm sorry?
The garage that is currently there, will you be residing that as well?
That's correct, yes.
And I think if the board members would look at, we did include 4 photos that shows the house the way it sits today. So if you look at that and look at the plans, you can see that it would be quite an improvement. And actually, in the first photo of that house, you can actually see the house next door that we were just talking about on the left. So the size here of the Knowles home is much more. It's smaller, but I believe that Mr. Farnan's design would be an improvement to the neighborhood. It's not going to be a detriment to the public, and it's going to be the public good, and it will not substantially impair the intent and the purpose of the zoning plan and the zoning ordinance. When we looked at this, that part of town there's ample off-street parking, but as Mr. Hurlis indicated, there's 5 spots that could be stacked up, and that's not including one spot that would be in the garage. So I know the floor area ratio is always, as Mr. Joe Ross would always say, the death toll. I think in this case, it's 3%. I heard, the board talked about, this is where you get the variance. And in this case, we hope that after hearing from the Knowles, hearing from Mr. Farnan, that they would approve the relief that's
So,
requested.
so excuse me, yes. Going back to the picture, which does show that this is a rental, and you're stipulating that it is only rented 1 month out of the year?
It is, August.
Okay. And so I think I've heard testimony that indicates a lot of, approval around maybe a C variance, but I'm not really hearing how this becomes, how this, not doing this would be an undue hardship to this. I'd like to.
Well, it's an undue hardship because it's an non-conforming lot, It's a non-conforming structure.
But it's currently-
There's really nothing
right.
that they can do to change that.
No,
as far as
understand that, but I think what I'm getting at is if they're not approved, they will still be using the property, it just would not be,
I think you heard Mr. Knoll say that if it's not approved, he's going to have a hard time accommodating his family, not the rentals. He's really not concerned about the rentals. You heard testimony that he said that his son was in San Francisco. He moved back here. They're spending more time down here. And for him to be able to accommodate that part of his family, that's what has really driven this. I think the biggest concern that we had in regards to this was, the use variance that was triggered by the floor area ratio.
yeah.
And that's really where we're at. I mean, I think that's what.
Yeah, I mean, that is obviously the biggest concern here.
The other part of it, I think it would be an improvement to the neighborhood. The design fits in much better with the houses to the left and to the right and also across the street. And for that reason, we would just ask that the board would consider.
Yeah, I agree with the design aesthetics. I don't have an issue with that. I do think, the improvements would fit better in with the streetscape. I just am concerned about the floor area ratio change.
Thank you.
Anybody else have any questions? Mary, anything? No? Okay, we'll have Craig do his report.
Yes.
Good evening, everyone. My latest review memorandum for this application is dated February 15th, 2022. This is a project located in the R2 low-medium density residential district. The applicant is proposing to add an addition on the rear of the structure that increases the floor area to 2,147 square feet and increases the total bedrooms from 4 to 6 bedrooms. With regards to the completeness review, so the checklist requirement for the details for C&D variances, item number 19 and 28, I recommended be provided as conditions of approval. That would be the topography, as well as providing drainage calculations for drainage facilities. This project is overdeveloped with regards to lot coverage. 40% is the maximum permitted where 55% exists. There's a recommendation in my report that asks them to reduce the amount of coverage. We have a 50% reduction if you provide pervious parking surfaces. I've asked them to do that. That would take the impervious coverage down to 46.4% if they agreed to do that. So we would be asking for that. So those should be conditions of approval if the applicant agrees to those.
Wait a minute, Craig. You said that would go down to 46?
The 55 would go down to
55 would go
40.
down.
Yes.
Does the applicant agree to do that? Then I can change
Right.
the chart now.
Mr. Knoll, basically what they're asking is to change the parking surface to basically paved. That would give you a 50%. I think you have concrete there right now.
There are 2 rows of concrete just for the wheel drive. It's
Right.
not a solid.
Right, and if you took those and changed them to pavers, it would give you a 50% reduction. I think that's what Mr. Hurley
That's what we're asking for.
recommending.
And then that whole area out just right there at the garage, too. Right.
Yes.
The whole thing.
We're asking for you to replace the entire driveway with pervious pavers.
Well, I can do that.
Okay?
Okay.
Mr. Harless, does that satisfy, I'm sorry, does that satisfy both 19 and 20?
So 19 and 28 would, 19 and 28 are the results. So I made 2 recommendations in my report. One is to provide a stormwater system because there are stormwater issues in this neighborhood, and the lot is overdeveloped, goes over on lot coverage. So we've asked them to do that as well as provide pervious pavers. So there's 2 recommendations in my report.
Does the Environmental Commission look at this, our committee? Because of the already
We didn't
overdeveloped
get a
lot?
report from them.
Okay.
The Shade Tree Commission recommended approval, and the fire department did. We didn't get a,
Is that when you have a lot that's overdeveloped like this, not a standard? Okay, just my own.
That's not the Environmental Commission. You look to Craig for advice on that.
Okay.
yeah,
fine.
so
Thank you.
let me just go through the rest of my report,
Yeah.
and we'll
46.1, which
46.4, we'll take it to. Okay, item number 23, which is the location of trees, they asked for a waiver, as well as item number 33, they asked for a waiver from providing a landscaping plan. They're not indicating any landscaping changes, so we did support that and recommended deeming the application complete. On page 3 of 5, in my table, I highlight the nonconforming situation. This is an existing nonconforming lot with a nonconforming structure on it. So the lot is nonconforming with regards to lot size, 7,500 square feet is the requirement in the R2 district. 5,000 square foot exists and will continue to exist. The lot frontage requirements are 60 feet, where the lot is only 40 foot wide. So those are the lot irregularities or nonconformances that have to be addressed. The structure itself will have, this is a vertical expansion, so the structure is nonconforming with regards to the side yard setbacks on both sides. There's a 15-foot total, and each side has to be a minimum of 5. So you need 5 foot on one side and 10 foot on the other. We have 9.6 foot on one side and 3.9 on the other, and they are vertically expanding that. So light, air, and open space theoretically could be compromised if to the adjoining neighbors. So that is a variance that's required. Lot coverage, I talked a little bit about. 40% is the maximum permitted in this district. The applicant has agreed to provide pavers that will take that situation down to 46.4%. So they're bettering as non-conforming situation in that case. And then the floor area ratio. So this is one of the lines in the sand that the zoning board draws. So there has to be a compelling reason to go over on the floor area ratio. And that is our as set forth in our master plan, that is our control on the massing of structures on a lot. And that is a ratio of the amount of square footage in the dwelling compared to the total lot size. So that's a ratio of how it's a control on how much massing you can have on a site based on the size of the lot. So, and they've given you some testimony with regards to that. This board historically has made sure that the applicant has some compelling reason, and they've indicated there's some architectural reasons, but that's for the addition in the rear. So those are the variances. With regards to the general review comments, these should be conditions of approval. One is our standard condition that they have to comply with Chapter 258 of the Flood Damage Protection Code. Item 2 is the recommendation to provide the driveway as a pervious paver surface, and that reduces the overall lot coverage. Item 3 is to provide a stormwater system and connect that system into the roof gutters. Item number 4, is the applicant agreeable to that? Let's stop on that.
I'm not sure what you mean by a system.
Okay.
What are we talking about?
It's usually a pipe and stone trench, recharges the runoff from the roofs into the ground before.
Well, does it run out to the street, or?
When that system fills up, it generally does, yes.
Is this something that goes the whole way around the house, the trench?
Usually on one side or the other, yes.
That's what we need. I guess we will stipulate to that.
Okay. So that should be a condition of approval. We've asked, there's one street tree requirement, and we did see that there was one out there, so we would just ask that be provided on the plan and show that it's to remain. Our standard condition is number 5, that the sidewalk adjacent to the site will be replaced to the satisfaction of the board engineer. Item 6 is our standard condition that there is an inspection escrow and that the certificate of occupancy is tied to the acceptance of improvements. 7 is the applicants comply with the requirements of the Cape May Shade Tree Commission, and their review dated 2/16/2022 indicates they're approved and no conditions. 8 is compliance with all other state, county, and local approvals. 9, this project is located within the historic district, so HPC approval is required, and I believe you indicated conceptual approval has.
We have final approval pending
Okay.
this decision.
All right. 10 is compliance with any and all applicable affordable housing requirements at the time of approval or issuance of building permits. And then finally, the applicant, if the board grants approval, they're required to submit the requisite number of compliance sets that have been revised to meet the conditions that the board sets. So that was a summary. I'm happy to answer any questions the board has.
Anybody have questions? Questions for Craig? At this time, I'm going to open it to the public. Anybody that's within 200 feet that would like to speak? Okay. Give us your name and your address.
I'm Patricia Gray Hendricks. I live at 106 Trenton Avenue, where I've lived for 37 years. It's kind of,
And I know you know this. I'm going to remind you that I have to swear you in.
go right ahead.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Absolutely.
And could you say your address again? I know where the house is, I just don't know the address.
106 Trenton Avenue.
Thank you very much. Go ahead.
I think one of the things when you've lived in an area for a very long time, you learn quickly that things around you have an effect. And one of the things I was going to say is I was listening to people talk about the neighboring house and how much larger it is, the house to the left. If you look at the 1303, that's the result of no FAR. That house was set on fire by the Hurricane Gloria in 1985 and was put out when a boat came down the street to put the fire out. The owner left that house and abandoned it and then decided to sell it. And the people that live there now purchased a one-story shell. And that shell was improved, and that person has lived there since 1986. I think there are a lot of improvements. I think FAR is difficult for many people. The only thing I wanted to say was that also when the Olivers made that second floor half of the house addition, it was because of FAR. And secondly, one of the reasons why you have on the second floor the knee wall is because they were specifically required to make it a certain height because of requirements by what the construction office said. So that was just a little background in history. So I appreciate family. Family means everything to all of us that are sitting here in the room. But I would say that the only thing I would say as an owner and in the neighborhood is that if you're willing to perhaps make it conditional with regards to your keeping the occupancy at 10 and not increasing it, I don't know whether that's possible. Or secondly, the fact that you're saying that you're limiting the rental. I mean, those are things that you want to influence the zoning board, and I'm only thinking that it could perhaps help you if you were to make those conditions.
Traditionally, I don't invite those conditions. I normally try to instruct the board that they're not, to not consider rental or non-rental in its analysis. And also, they're very difficult to enforce. Resolutions aren't something that a person who buys the home is required to review in making a decision to buy the home, so they might not be bound by it. So normally, if we have any kind of condition like that, are required to be in a deed. I don't recall doing it for rentals, but we've done it for some other things so that it would be part of the chain of title. So I'm not saying anything the board's going to do, it's going to do. I'm just pointing out that has been challenging in the past to impose on the initial owner, to impose on a future owner, and then to enforce when it's violated. They can be difficult to do. But doesn't mean.
Yeah, I think it's a good point, though. This is being presented to be further developed on an already, undersized lot. And the condition for that variance is being requested because it's a hardship because of family reasons. It is a rental property, there's a sign on the lawn. You are stipulating that it is only 1 month out of the year. So I feel as a board member that, potentially approving a D variance under the hardship of that you want to be able to extend your home to your family now that your son is back in the area, I can fully appreciate and support that. But I think that we're caught into a little bit, and personally I'm having a little bit of a conflict and feeling that really, if that's the justifiable reason, I do feel that it should be somewhat of a condition, and I understand how challenging that is from a compliance standpoint and to ensure that it is, but it would be my reasoning for approving it, that this is not a rental property to expand upon bedroom capacity and revenue, because this is already, a home that is on a overdeveloped, it's overdeveloped on the size lot, and it's only going further. And I can appreciate that the design aesthetics for the back cannot be, taken down anymore because it's just not going to conform. It's going to look even more awkward. But personally, as I'm listening to Mr. Hurlis and going through all of the notes, that it's giving an approval on a D variance really is a threshold. And, I really feel like I need to hear that, how that threshold can be met. Thank you.
Thank you, Patricia. Yes.
I have to agree with that.
My name is Jean Rupinsky. My husband and I reside at 1307 New Jersey Avenue. So we're the house to the right.
Okay. Gene, can you spell your last name for me?
Sure, Rupinsky, K-R-U-P-I-N-S-K-I.
And Gene that one can go a lot of ways.
J-E-A-N.
Thank you very much. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you.
So we live next door, not 36 years, only a year and a half. So we renovated that house, the big gray one that's next to it. Knowles are a very nice couple. One thing I want to say is we were never notified of this whole thing. So I understand he pulled a list last August. And last August, even though we owned the property, we weren't really full-time here yet. We had a different address. And it had never made its way with the change of address system and layout, it never made it to us. So I would say for future, you might ask people to pull lists closer to the date of this. And if it hadn't been for one of the neighbors notified, we would have never known.
Oh, I'm going to say two things to that, okay? First, you're right, factually. Our ordinance, our application, because I was asked to look into this, and our application says that you have to get the list within 6 months of when you submit the application. So this application was submitted, but for some reason wasn't heard for a long time. I don't know all the details, so I'm just telling you that it did comply with our instructions, but I do think in the annual review that the board does of its stuff, that certainly could be a topic to be addressed, and it really shouldn't be just in our application, it should be in our ordinance, and maybe require the list to be within 6 months. But I would also point out that there's a public notice requirement that's actually published in the paper as well. So that, what's that?
I get that Star and Wave.
Well,
It's not the Star and Wave.
That's not the paper, what's the big thing?
It's the Herald now.
Oh, the Herald.
It's the Cape May County, it used to be the Star and Wave.
I'll pick it up at the grocery store.
so, and I'm not blaming you, I'm just saying that there is a kind of a backup system where there's a general notice of that as well, so,
You guys to take a look at that.
but you're here tonight, so we're glad you're
Your
here.
annual review. So we live next door. We certainly did a lot of construction on that house. There was a nice kind of berm of horrible trees and stuff that we now pulled down and have unfortunately exposed them. We also put a pool in, right, so that has caused, but it's a tight lot there. It's a tight lot. Before we lived on New Jersey Avenue, we lived next to Roger and Heather on Hugh Street. And when Roger and Heather sold their house, it became a whole house rental. And that's why we moved, because there were 22 people in that house. And because there wasn't a lot of room in the house, they were pouring out of the house every weekend. So 22 people just pouring out of the house. So the rental is the only thing that concerns me, is that if they had the ability to rent, I mean, it's 6 bedrooms, you guys, it's tight there. Like, I'm not sure it's a real hardship for them, you could go sell the house and buy something else, right, in town. But my feeling is, if we could somehow restrict the rental, that is the thing that concerns us, because we dealt with that. And that now it's a tight house on a tight with 6 bedrooms. That's a lot of bedrooms for that. And that's my only issue. I don't understand this floor to ratio or whatever that is. I'll leave that all to you guys. But just as we continue to build in Cape May, that, you know, we need to take into account of that. So I'm supportive of that addition if somehow we could control that they cannot rent it and end up like we were on U Street with 22 people.
Yeah, I believe you're preaching to the choir as far as I'm concerned about the rentals. Being a long-term resident of Cape May, I'm very concerned about that. We have lost significant population in this city, and a significant portion of the houses here now are unoccupied except for rentals. But like Mr. King said, I don't know how you control that. I just don't know how you can do that. I mean, a deed restriction is very unusual for controlling rentals and that kind of thing, so I don't know.
Yeah.
It's an interesting point. I wish I had an answer for that.
And that area is mostly people full-time. You know, that's one of the reasons why we like that area, because it wasn't big on rentals, other than, and they, last summer only did rent it for a month, I guess about a month.
We run it in the month of August.
Is that what it is?
Yeah.
But that's my only concern. I mean, certainly they're great neighbors, and it would be nice to help them to do this. But at the same time, you know, that rental piece is very concerning. Or if they sell that house, right now, they're adding 2 more bedrooms. My God, what is that, 15 grand a week or something in Cape May at 6 bedrooms? And what's that gonna be if they sell that property? Then what are we, you know, we're left with a big house rental.
Yeah, it is a concern. I'm not sure it's within our power to do anything about that. I defer to our counsel here.
So I don't know if we control that through these
Right,
Florida, whatever ratios or whatever you guys have set up. I don't know. But they're a nice couple, you know, it would be nice for them to have that, but the concern would be if they sell it and it becomes a full house rental, or if there's any way we could control that other than, you know, whatever the powers are. And thank you very much. I appreciate it. Nice meeting you.
Well, thank you.
Anyone else? We'll close it to the public at this time.
Mr. King, I know you say it's very hard to, but I can tell you, I just asked my client whether or not he would be opposed to putting on here a rental restriction of 10 people, and he does not have a problem with that. He just advised me of that. Now, I just don't know how we,
Yeah, how do you control that?
how do you control
can't.
that?
You've got, you know, normally 2 people in every bedroom, so, you know, got enough for 12 people right there. I think 6 bedrooms is a lot, too.
Can I say something?
Sure.
We have 4 adult children with spouses and us. And the rooms are not large enough to accommodate 2 couples to a bedroom. So we can't have our entire family there unless we have 6 bedrooms. And that's the main goal of this, so we can accommodate our family.
Well, I mean, I've given this speech before, but, you know, you weren't here, which is understandable. It's very hard to do zoning based upon the activities of the person that currently owns it. Because once we grant a variance, it's there forever. It runs with the land. So just as if you were, it's just hard to do variances based on the individual, you know, this is, I only have 1 child, so we're quiet, but the next person that moves there might have 7 children. So it's hard to do zoning that way. I'm not telling you that you're wrong for saying it or anything, I'm just reminding you that we're doing zoning. So it's not always it is what it is. Board can take it.
And for us to go and buy a larger house is easier said than done in this real estate market.
Yes, we're all very aware of that.
Okay, you want me
Yes, go ahead, make your,
to talk? You guys want to talk?
anybody else, any more discussion?
All right, I'll give my floor area ratio, a speech that I've given a number of times. First of all, the standard for floor area ratio is the reason I asked the question I read. And understand the standard is like a bit of a mystery, okay? We all pretend that there's a real standard for floor area ratio variances, but it's based on some case about a shopping center, and it doesn't really make a lot of sense in the cases that come before us. And Mr. Amenizer, I think you're the attorney for which town?
Give me a point.
Give me a point, is that where you sit?
That's right, yes.
Okay. All the attorneys struggle with the floor area ratio variances and articulating the basis for it, but it's supposed to be, the site will accommodate the problem associated with a floor area. I was wrong with that. Will accommodate the problems associated with a floor area larger than that permitted by the ordinance. So what does that really mean? Well, we've done our best to apply that to our master plan, because that's what's supposed to guide the things we do, okay? So the things you consider, and they've addressed some of them, okay? Which is parking. So if they're adding a bunch of bedrooms and that increases the parking, there's not enough parking, you could say, well, that doesn't seem to, that excessive space doesn't seem to, the site doesn't seem to accommodate that excessive space because it's causing a parking variance. Lot coverage is another one, okay? Sometimes one of the other indicators that the proposed expansion is too much is because you're increasing lot coverage and it's more than required, and then you can say, well, it can't accommodate because there's lot coverage. Okay, so those are the real clear zoning ones. And this one, they did try to mitigate the lot coverage, although it is above our standard. They tried to mitigate that a bit, and they agreed to make a change related to that. One of the other things that we talked about in past applications was massing. That's what Craig calls it. Massing, meaning the size of the building. Does it look big for the lot? Okay? And when we talk about that, we get into, light, air, and open space around it. How does it fit in with other buildings around it? How does it look from the street? And for that reason, some of the floor area ratio variances that we have granted, the very few times we have, are where they're filling in holes in a building. I think it was on Hughes, one of those streets where there was like literally a hole in the building. We filled that in. Sometimes in the back of a building where it's not visible to anyone. So that kind of goes to massing, but also the overall size. And you've heard some of the comments of the public that really big buildings attract more people, more intensity of use. So one of the things the floor area ratio does is it kind of sets some boundaries on how big things can really get, even though you meet side yards or stuff like that. So those are the things that I think you have to give some thought to as you decide whether, Mr. Hurlis used the word compelling, and he didn't mean that in a legal sense. So we're not applying a compelling standard, because that word has meaning in law, okay? So we're not applying a compelling standard, but what he meant by that was he was summarizing the things that I've just talked about, that we look for reasons to do it because we can't do it in every case, okay? So you have to decide if the reasons you've been given tonight are sufficient to justify in your mind that the site can accommodate the floor area ratio increase that they proposed, okay? I know that's not perfectly understandable, but that is the best I can articulate it. The only person who might do it better is Ms. Kufiel, maybe, but that's the best, or Ms. Morrissey, the best that I can do in articulating that. And I've never heard anyone do it much better than that. I mean, it's just hard to articulate, I think. Me either. For us, in the sense that I try to incorporate all the things I've heard talked about by others as best I can. I'm not saying I did it the best. I'm saying I tried to cover all the different things that I've heard talked about in the past. So just give them, your best analysis and use your discretion and exercise it wisely, okay? And articulate the reasons why you do the thing that you choose to do. I believe this requires a supermajority too, 5 out of 7, because it is a D variance. So you need, if that means that 5 have to approve it for it to pass. If 4 do it, just because it's a majority, it doesn't pass. And then we have some new members. I'm just catching up on that. Sometimes it's 4 out of 7, sometimes it's 5 out of 7. This one's a 5 out of 7, okay? Does anybody have any questions? Anything?
The only thing I would just like to just emphasize again is the percentage. It's 3% over the 40%. I know we talked about the house to the left. If you're looking at the Knowles property, I believe the floor area ratio on that was 68%.
All right, well, we're,
I'm just
okay, I just
trying to
take testimony, let me have it from someone sworn in.
Certainly. So based on the tax records, I could say definitively that the house to the left is over 60% floor area ratio. And I understand from public comment that it occurred before, an ordinance implemented that, but we're talking about 20% in excess of the permitted floor area ratio, whereas our project is 3%.
Technically, I committed a boo-boo because I took extra testimony after the public was closed. But
And just one more thing, that lot is the exact same lot as the Knolls, is that correct? Same size, square footage?
That's correct.
so the motion that I'd recommend being made, but how you vote is up to you. It's and I'm going to present it as a whole because you presented the project as a whole. So you need 5 out of 7 on the total vote. And the variant is a motion to approve the project as proposed with the variances 1, 2, 3, 4, and 5 on page 3 of the engineer's report, with a lot coverage of 46.4 as a result of putting in the pavers. And that's the motion. That's the motion that I recommend being made. If anybody wants to make a different motion or add other conditions to it, that's up to them. I try to articulate one, but if anybody says you want to add a different condition or something, I'm leaving that to the board. I'm not deciding on it.
Got anything, Bill?
No, I was going to, if you're finished, I'll make the motion as you articulated, if that's what the chair would like.
Okay, and there was talk about a condition about tenancy, and I'm not, if somebody wants to do that, I'd like to talk about it a bit, but I didn't propose that in the motion. But if somebody wants to do that, now's the time to discuss that or do it. If
Can we,
someone makes the motion.
yes, can we discuss that? Because I'd like to understand whether or not that's at all possible. Given the testimony of the neighbors and just understanding what we're,
Is it at all possible? I've never done it.
okay.
That doesn't mean it's not possible. It just means I've never done it. And I'm not sure if you're asking me to make it no more than 10 people or no renting, but I would tell you that that would have to be a deed restriction, because no one will ever find the ordinance if they sell it. And it can be challenging, but if what I'd like to do is, I'd like to have 2 votes, okay? So, I'd suggest that you vote without it and see how it does.
Okay.
And if it wins, then it doesn't matter. If it loses, then I'll allow, which I usually don't do, a second vote, a second opportunity to make a motion. And if someone believes that it should be granted with that condition and they want to do it, okay? So it's been rejected once, and then they want to make it with that motion as a condition, then someone makes that, and then if they get a second, you'll vote on that. If no one makes it or no one gets a second, then you won't. But if someone thinks that it should be approved with that condition, then they're free to make that motion after you do this first vote, okay?
Madam Chairperson, are you
Is that okay
agreeing
with you, Madam
that?
Chair?
It was a little complicated, I'm not sure.
You want me to do it again? I'm trying
No,
to-
I got it. First,
You
we're
got
doing it without the condition. Let's see what happens.
Okay.
Okay, are you ready to entertain a motion? Okay, I will formally make the motion as articulated by our counsel.
Need a second.
Do we have a second?
Somebody needs to second it.
I'll second.
Thank you.
Okay, we have a motion by Mr. Murray, seconded by Mr. Venuto. Mr. Walsh,
No.
Mrs. Notch,
No.
Mr. Ledwin,
No.
Mrs. McDade. No. Mr. Venuto,
No.
Mr. Murray,
No.
Mrs. Hutchinson.
No.
Now, if anybody is of the belief that it should be approved, if it has that condition, then make that motion, and if anybody also wants to do it, then they can second it, and if there's no motion, then it dies, but I'm giving that up.
Let me ask you this question. If we were to do that, and what effect does that condition of approval have on the property itself? Like you say, it usually would have to run with a deed restriction if you want to.
It had to be in a deed restriction, and that means that they they ever sold it, the buyer would be
Right.
subject to the deed that says.
Right, but-
I think it depends on the motion.
Okay, well, if there is no deed restriction, and we do make the second motion conditioned on that, on limiting the rentals, how does that affect them? I mean, what if they don't abide by that? I mean, how do you enforce that?
You know,
I'm not saying you wouldn't, I'm just saying, this is hypothetical.
well, it's a little different than any other because it's also a deed restriction, so I would write it in a way that it's intended to benefit both the city and the neighbors so that theoretically neighbors could enforce it. It's a little, there's some law on that. I actually had to deal with that once on the mall. So I would draft it in a way that would attempt to allow both the public and the city to enforce it. But, you know, that requires knowing how many people are staying there in a given week and all that. You know, it can be challenging, but I'm not foreclosing the opportunity to make the motion. And if you guys grant it, I'll do what I can to make it enforceable.
I can tell you, I spoke to my client, he did originally a rental restriction to 10 people, he was okay with that. I think he's concerned about giving up a property right.
I'm giving up a substantial property right. And it's going to impact the value of the property down the road. And so for a pro deal here, you give me this and I'll give you that,
Well, that's not what it is, sir. You lost already. So you don't have an addition.
yeah, I know.
So, and I'm not even, it's not even sure if you make that concession that you're going to win. So
right,
it's not a quid
yeah.
pro quo. I view it this way. Part of the site's ability to accommodate this addition may be what you do with it. So I can kind of, this one's a kind of a different weird standard. So maybe if you agreed not to rent it and at all, maybe that makes the site more likely to accommodate. I don't know. There's no case on this. But you're right. If you do this addition with that condition, you will, and if the board agrees to do it, they haven't even agreed to do it, they may not. But if they did, then, you know, if you do the addition, you may never be able to rent this again, and that's a big deal. So.
Well, not only that, but I have to sell it with that restriction
That's,
if I do sell down.
that's the motion, and that's what's approved, and that's what you got, yep. Now, you can never do the addition, and it doesn't matter, so.
Rich.
I'm just saying that if you want to forego the vote, then.
I have a question to the architect. Is there any way you can modify your design to get it under the, or equal to the floor area ratio? I mean, you'd have to defer tonight, but we've done that before.
Modifying the design to accommodate or to comply with, I should say, the floor area ratio would entail the reduction of 150 square feet approximately, which is one bedroom effectively. So they're not achieving what their goal is for the project. Could we design an addition, right, with no specification, but an addition that complies with 40% floor area ratio? Yes, but it would not accomplish what it is they're seeking to accomplish.
Now, you're accomplishing now with the extra 150 feet, another bedroom. How many bedrooms would there be with that?
I'm sorry, could you repeat
How many
that?
bedrooms would there be if they followed your design right now?
6.
The proposed.
Yeah, your proposed design.
It would be 6. If we-
Okay, if you knocked off 150 square feet, how many would there be?
5, it could be 5.
Okay, so, that's great. Does anybody want to make another motion?
It doesn't seem,
To what? To take the 150 feet off?
no.
No, if you want to make a,
No, I don't.
if somebody felt strongly that they would grant it with the condition, they want to have the opportunity to make the motion. If they don't make the motion, they don't make it. Doesn't sound like he wants it, so it's fine.
Mr. King, and I'm not sure whether we could do this, could we make it an approval contingent upon being 40% floor area ratio, so that it would leave it open, that Mr. Farney could go back and comply with the floor area ratio?
Would we have an opportunity to review, just to review the final plan, or would that be left to Mr. Hurlis to do?
Why wouldn't we? We've done For why don't we
Okay.
just defer, ask the applicant to defer till next month and let them see if they can work it out?
Well, there seemed like there was a couple of important things. One, the floor area and the number of bedrooms was the concern. So I would ask that, if you're directing me to review it as a condition of approval, I would need to know how many bedrooms that you're limiting it to, if it's 5 or 6.
Can I interject? I would say this, that if we hit 40% on the floor area ratio, that takes away the use variance, that takes away the majority vote. So if we could get a motion today saying that they approve it based upon them being within the 40% FAR, then I think you would be done. There wouldn't be the need to talk about 5 bedrooms, 6 bedrooms. As long as it's within the floor area ratio, that's the triggering thing, and that's just my.
I still think there's a concern, there's a lot of discussion about the number of bedrooms and how intense.
Yeah, the
That's-
light and open air issues are still on the table. I mean, there's still other things that the mass and density would be compromised at this point if we didn't have an opportunity to understand those conditions. So I'm not necessarily in favor of just acquiescing and saying it's just the 40% and, we're okay. That's my opinion.
Well, that's why my suggestion is that the applicant defer for a month and let them bring it back to us.
They've already lost, so they can file a new application with
okay.
revised plans at any point. I mean, that's their decision, they can do that. Their application would be substantially different than what we're seeing here, so.
New application would make it cleaner, right? I mean, we'd start all over again with a new application. You would not have this excess FAR on it.
I
Okay.
think I'm looking at from a financial
Yeah, I understand that.
Are there, I don't want to, I want to give them a fair chance, but I don't want to overthink it. Are there bulk variances that we could grant so that if they redesign it, that they comply with the floor area ratio, that they already have the bulk
side
variances?
yard setback variance would be the C variance that I think they would seek. And the other one would go along with it, but as far as the structure is concerned, it's the C variance side yard setback variance.
So if we were to pass, if we were to make a vote that we are granting the bulk variances as requested, subject to the condition that it comply with FAR and have 1 bedroom.
Yeah. You would essentially not grant the FAR variance.
Right, that's what I'm saying, I'm just making sure that, and also the 1 bedroom thing, if that's what we approve,
Right.
then I think they could they could move forward with that without having to come back if they do meet the floor area
Yeah,
ratio.
if that's acceptable to the board, I mean.
Mr. King,
Mr.
can you
King.
state that again? I know you, yeah.
I will, I just
Oh,
want to hear
sorry.
what the professional designer says as opposed to the lawyer designer.
It's quite all right. I just want some clarity, if that's okay. Assuming that we can comply with the 40% floor area ratio, and assuming that we are granted side yard setbacks relief, given the fact that we can fit 5 cars, is there any recourse for this board to actually limit the number of bedrooms? If we provide the adequate parking for 6 bedrooms, if we find a way to make 6 bedrooms fit within the 40% floor area ratio permitted.
Well, I mean, we are granting bulk variances, and one of the factors of that is a negative criteria. So there has been testimony from the public that the extra bedrooms create more intensity of use. So I think that they feel that it does negatively impact them. So I think the board would be justified in doing it. Doesn't mean they should, or they would, or they can't. I'm just saying that I think there is evidence on the record that could support them finding and granting a variance for the bulk variance for the side yard, because you're vertically expanding it, to say, look, we don't mind vertically expanding it, but we don't want to do that if it's going to create 6 bedrooms on a relatively small lot. So I think they could do that in a variance analysis. So it's not like a by right just because it doesn't have a floor area ratio variance.
So just for clarity, and this is really just for my own knowledge at this point, but if we didn't require any variances on this project, would there be anything preventing an additional 2 bedrooms?
If it passed by the zoning officer, it would never get to us. We didn't even know about it.
Right.
But when you come in for a variance, you got to consider the impact on
Certainly.
surrounding properties and people, and there's testimony about that, so it would be okay. I'm not saying it's the only choice, I'm saying it's.
Right, right. I understand, appreciate
So
that.
I think what you're hearing, I think the consensus, what I'm hearing, I could be wrong, the chairman will correct me if I'm wrong, is that if this didn't violate floor area ratio and it had one bedroom and a bathroom, we perhaps grant the bulk variances you're seeking and the non-conforming width, non-conforming frontage, all those other bold items in the engineer's report with the lot coverage at 46.4, you might not have to come back if you design it in a way that meets those parameters. But that's up to you. The other option is you can go home, take out your pencil, draw something with 2 bedrooms and a bath that meets floor area ratio, and come back in and take your chances and hope for the best. And that might not be a bad choice either. I'm not telling you what, we got to do something because we have another application that's 10 of 9. Right, did I say that right? Mr. Farnan, how big's the other bedroom?
I'm sorry?
How big's the other bedroom?
There's one, I'm sorry. There's one bedroom that's about 120 square feet. There's one bedroom that's about 150 square feet.
You're not gonna be able to make 2 bedrooms out of that. When you take that down and make the 40%, I don't know the math, but it's gonna be really, you have 2 closets.
Right.
I think we would like to move forward with the bulk variances, just so we can get that with the five bedrooms at this point.
Well, the motion I recommend being made, just because we approve it doesn't mean you have to build it, but the motion I recommend being made is a motion to grant the variances for lot size, lot width, lot frontage, side yard, each side yard, lot coverage at 46.4, but not a floor area ratio variance, subject to the conditions outlined by the board engineer and the additional condition that it'll be 1 bedroom and 1 bathroom in the addition, and that the whole project will meet the 40% ratio to the satisfaction of the board engineer. That's the motion. I think that's what I heard.
And you just remember that there's only a simple majority for this because there's no D variance.
That's right.
Did you want to?
Yes.
Okay, I will make the formal motion as articulated by our counsel.
Second.
Motion by Mr. Murray, seconded by Mr. Ledwin. Mr. Ledwin?
Aye.
Oh, thank you. Mrs. Notch?
No.
Mr. Walsh?
No.
Mrs. McDade?
Yes.
Mr. Venuto?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
I have 5-2.
Okay, yeah.
Thank you, Madam Chairman and Board, and Mr. King, Mr. Hurlis, thank you for your time.
Thank you, ladies and gentlemen, thank you.
Thank you.
How you doing?
Wait patiently. One second.
Sure. How are you?
Good, how are you?
Good, good.
Hello, hello.
Good evening.
Thanks for sticking with us.
Oh,
Yes,
thanks for being so patient.
yeah, it's been very interesting night.
Good to go? All right. Madam Chair, members of the board, thank you for hearing us tonight. My name is John Amenhauser. I'm an attorney with the DeWeese Law Firm in Wildwood, here this evening on behalf of the applicants, Walter and Anna DeForest. This application pertains to property located at 1500 Velvento Avenue here in Cape May. It's identified on the tax map as Lot 1.01, Block 1176.02, and it's located in the R1 zoning district. Prior to tonight's hearing, we did receive information that this application received approval from the Shade Tree Commission, as well as the City of Cape May Fire Department. And through this application tonight, we're seeking variance relief from the design standards pursuant to section, or chapter 525, section 62A1, and section 57E3, pertaining to request for a swimming pool in the front yard and the allowance of a 6-foot-high vinyl fence in the front yard along New York and Baltimore Avenues. With me this evening, I have the applicants, Anna and Walter DeForest, as well as Tiffany Morrissey, a professional planner who will testify this evening. If I can have them sworn at the same time.
Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All of you, actually.
And I do believe Ms. Morrissey's appeared before this board on a number of occasions in the past. If we accept her qualifications, then we putting them on?
Yes.
All right. Ms. Morrissey, can you provide the board with a general overview of the subject property and its current use and intended use?
Yes, so I prepared an exhibit for you. I didn't prepare the exhibit. Basically, it's the plan that you have, but blown up so you can actually see it. So I just zoomed in on the plot plan portion of sheet 1 of the plans prepared by de Blasio and Associates dated February 22nd, 2022. No revision date, the variance plan. You can see the zoning table, the important stuff. You don't have to see all the other stuff, and you can actually read it. So this property is located on New York Avenue. It is part of a subdivision that was approved by the planning board back in 2006 and amended in 2015. This property is in a block that is unique in that it has the reverse frontage lots, more or less. And what a reverse frontage lot means is that you have a street in the front and a street in the back. This lot is even more constrained because it also has a street on the side. So this is at the end of that block. It has 3 street frontages, and it's located in your R1 zone. It's on Velvento Avenue and Baltimore, and the reverse frontage street is New York Avenue. The request this evening is to provide an approval for a pool in a front yard, which sounds like an egregious ask, except for there are 3 front yards on this property. And because there are 3 front yards, we're looking to provide an opportunity in what is their technical rear yard and how the house is oriented. All of the homes in this subdivision will be oriented toward Velvento Avenue as their front yards. The rear yards along New York Avenue, which are on a street, the functional rear yards are constrained by a 10-foot landscape buffer, so there will be no interior or vehicular access permitted out to New York Avenue. So that 10-foot landscape buffer would exist and not be impacted by the proposed request, and the request here is to put the pool between the house and the landscape buffer. So if you look at the plan, which is in front of you but easier to see here, the house is oriented towards Velvento. We have a 25-foot front yard setback requirement on all 3 sides and a 10-foot on one side, which is exceptional for the property where other properties will only have 10-foot side yards. We have an extra 25 feet. We propose a setback off of Baltimore of 27 feet and a setback to the house off of New York of 32.1 feet. Mind you, your rear yard setback requirements, if this were a traditional rear yard, would be 30 feet, so we actually meet your traditional rear yard setback requirements. And the pool would be located between the house and the landscape buffer. And then, because of the ordinance requirement of each of these being considered front yards, would be located in a technical front yard. Your ordinance does allow a pool in a front yard as long as it's, well, it doesn't necessarily. It has to be back 25 feet and behind the side of the building. So there's no other location on this property where you could functionally put a pool. We also request a variance for a solid fence. Given the openness of this lot and its location, the desire to provide some level of privacy, especially with the outdoor living area, we are requesting a 6-foot vinyl fence, which would be solid. That fence is not allowed to be 6 feet in a front yard. It's allowed to be 4 feet. Again, we have all of these front yards So in order to provide the appropriate privacy space in the outdoor area and provide the appropriate protections for the swimming pool, we've actually pushed that fence back about 13 feet off of Baltimore Avenue. The site triangle on the corner of Baltimore and New York is shown. The fence will not encroach into that site triangle, and it will go along the back of the landscape buffer, in essence enhancing that landscape buffer. So,
Can I ask you a quick question?
Yes.
You said the rear of the houses are oriented towards New York Avenue.
correct,
On the other side of New York Avenue, there are big houses there.
there are.
Why, what's on the other side of what's it, Velvento? What's on the other side of
So,
Velvento?
so the subdivision plan, and
Yeah.
You want to step in at this point?
you can, because I can go through it, but you can do it since you're.
There.
So this is a
Just
unique
curious.
block. And this
Y-
is,
yeah.
I was the board engineer when the planning board considered this application and approved this application. So this was a 15-lot subdivision. Maryland Avenue is the next full block
Right.
up there. Where Maryland Avenue would run parallel to Velvento Avenue is all wetlands and wetlands buffers. So they could not improve that street. So we ended up with this weird configuration. Velvento Avenue was, the applicant brought forth the proposal to run Velvento Avenue in. When we did that, the board was tasked with, like, how do we develop this block that has frontages on both Velvento and New York Avenue? How do we deal with that? They heard from the neighbors on, especially particularly the neighbors on New York Avenue. And what was developed or through the plan was that a 10-foot wide landscape easement was set forth all along New York Avenue, along the block, along these lots that are in between Velvento Avenue and New York Avenue. And the intent of that 10-foot wide landscape easement was to buffer and ensure, like, because there's no penetrations that are approved through there. So you can't have driveways that go through there. So that essentially forced all of these houses to front on Velvento Avenue. So the board, through their actions and through the development of that 10-foot wide landscape easement, essentially treated those as a backyard. So all of the pattern of development that's in this block will essentially have backyards that are oriented towards New York Avenue.
So the neighbors on New York Avenue were aware of the impacts?
This is their preference.
Okay.
You know,
We're-
I can't speak for all of them, but the ones that showed up at
Right.
those meetings wanted this.
So were they going to understand that they're going to be looking at fences running along?
Yes.
Hopefully, we're going to look at a 10-foot landscape.
Well, yes, so there's, the fences have to be inside of that landscaping.
No, I saw the lots today, and I saw
Yeah.
the 10-foot, yeah, so is it intended to be all trees?
Yes.
Okay.
So eventually, there will be a landscape buffer that grows up along there. You know, they're immature species there, and a lot of them are not viable. The improvements for this subdivision have not been approved yet. Velvento Avenue has not been formally paved with a final top coat, so there are ongoing developments that are required, but eventually, yes, that will be supposedly an impenetrable landscaping buffer.
Okay.
Okay?
I also noticed on the notification list that this is still owned by Pella, many of the lots. So I feel that in some respects, you know, we're underserving people who would be potentially living there by not having them have the opportunity to opine on this application, in my opinion.
So your proposed fence will not encroach upon the 10-foot buffer?
The fence will not encroach on the 10-foot buffer. In fact, it'll enhance the buffer in terms of providing that screening along New York Avenue, because it would make it look not like someone's backyard. You see that in established neighborhoods where the houses back up to county roads or something, you can have those fences and landscaping combined. That would enhance that.
Because the big houses on New York Avenue
Yes.
face New York Avenue.
They do.
And now the houses do not face the other street, which if you looked out of the front of your house, you wouldn't see anything on it, right? On the other
Right.
side of it, there's nothing there, right?
And public notice was done for this, so those homeowners on New York Avenue received the public notice.
Oh, yeah, no.
Yeah, and I know, because I know you're concerned with the other homeowners that would eventually own in this development, but they're going to have the same reverse frontage
And I can
lot, and it'll be
speak to-
oriented the same way.
Those within 200 feet on New York Avenue receive.
Yes.
It's not everyone on.
Not
New-
everyone, within
Well,
200.
I can speak to the potential for future purchases, because my clients purchased that just this past year at the end of the year, and I can tell you that as part of the title search that was conducted, we received all of the approvals from the planning board, which included landscape plans, et cetera. So before we purchased that property, we knew exactly what the possibility was and what was required in terms of landscaping in that particular area.
But
So
then
anybody
you-
coming in would
yeah.
have noticed.
Well, then you would also have known that it was going to be 2 front yards because it's a corner lot.
3 front
Three
yards.
3 front yards. But
Right.
that was known to the owners,
That's-
the purchasers.
And that is fair,
Yes.
but
Yeah.
the variance and the justification I'm about to give is related to the lot, whether it's owned by this person or a different person. It goes to the shape and configuration of the property. But it's not just a hardship issue, because I think there are C2 benefits that are also associated with the proposed development. So just to go through the variance testimony so that you understand what we're asking for, the house itself conforms to all of your ordinance requirements. This is just about the fence and the pool. In fact, the lot coverage is less than the 30%, so we're not overdeveloping the property. And that's why I wanted to indicate also that we're also having increased setbacks. We have that 32-foot setback from New York Avenue where 25 is permitted, and we have 27 feet from Baltimore where 25 is permitted. There are clearly hardship conditions that exist that relate specific to the property having 3 front yards. Typically, in an ordinance, when you have a reverse frontage lot, corner lots you generally see, you have 2 front yards and you reduce your usable yard space. When you have a reverse frontage lot, which is what I call it when you have front to back, typically there are requirements and ordinances that do not treat that reverse frontage as a front yard. They do require no access, they do require buffering, but they allow it to act as a rear yard. And the definitions that are generally accepted through many ordinances and accepted in the latest illustrated book of development definitions that planners refer to do not consider reverse frontage lots front yards. However, your ordinance is permitted to treat them however you choose. It is not something common that you see in Cape May. You do not see reverse frontage lots. In fact, it's very unique. It's unique in many different areas. Usually they come about from a major subdivision in a different location that backs up to a county road. This is not what you really have in this location. So the reverse frontage, that rear yard, is usually treated as a rear yard with restrictions for it acting as a rear yard. Your ordinance doesn't provide that, which creates an additional hardship on this property because now we have those 3 front yards. The property the way we designed this was to be respectful of those areas and to ensure that the pool was located in a way that it was in the true rear yard and not in a side yard area, not pushing out towards Baltimore Avenue, but nestled behind the house and having that extra space and having that fence and that landscape buffer to screen it. In terms of the C2 criteria, the benefits in creating a better zoning alternative for a property, this subdivision design and layout resulted in a unique situation for some of these properties and specifically for these corner lots because they are more restricted than other properties within the subdivision. In terms of how we've designed this and what the benefits are, it's my professional opinion that the proposed pool, which meets your ordinance requirements if this were a rear yard, considered a rear yard, would promote purposes of zoning, including creating adequate light, air, and open space, and promoting a desired visual environment through creative development techniques and good civic design and arrangement, as well as providing sufficient space in an appropriate location for a variety of uses, and in this instance, an accessory use that is typically associated with a residential unit. When you have a residential home, you expect to have accessory uses associated with them, and this application provides that appropriate location for that sufficient space in this area. As I indicated, the adequate light, air, and open space, we're not overdeveloping the property. We're not asking for any coverage requirement variances. We're exceeding the side yard, the front yard setbacks on all 3 sides. Even the front yard will be set back 27 feet. So we've exceeded the minimum requirements on all of our setbacks for those front yards. And our side yard setback is shown at 12 feet. So we've even exceeded in that area. So we're not overdeveloping the property. We proposed that 6-foot fence, which would violate your ordinance in terms of being in a front yard, but we feel it adds a benefit to the desired visual environment in terms of enhancing that landscape buffer. That will protect the visual appeal, whether there's a pool there or not, to the neighbors across on New York Avenue or anyone going down New York Avenue, so that it doesn't look like you're looking into someone's rear yard and just have that landscaping. Because patios are permitted in the rear yard, people can enjoy that space. So that fence adds that enclosure. And we've designed that fence to go along Baltimore Avenue, but we're not asking to be out into the substantial front yard area. We're pushing it back 13 feet to give them a usable rear yard area where other properties are not impacted by that side yard issue and not being able to enclose their full rear yard. In terms of this application, the pool being located in the rear yard does not create a substantial detriment to your zoning ordinance. Well, it's a front yard, I should say that, but behind the house. Does not create a substantial impairment of your zoning ordinance or your zoning plan or master plan. The intent is to limit access and visibility along New York Avenue. Pools in a front yard are not traditionally what you want to allow. This is not a typical front yard. It is what I called and talked about earlier as a reverse frontage lot. And there is no possible location on this property to permit any type of accessory structure because of the restrictions associated with the way the properties were subdivided and with the 3 street frontages, and that your ordinance doesn't have a different provision for reverse frontage lots. The 2019 master plan looked at 6-foot fences in the side yard and wanted to make sure that they weren't impacting views in historic neighborhoods and making sure it doesn't interfere with any lines of sight or visibility. So when we looked at the master plan, we looked at and we looked at how to design the fencing on this property. That's why it's pushed back. It's 13 feet. The site triangle is shown, restricted. It's not in the site triangle on the plan as proposed, so it's not going to interfere with the appearance of a viewscape in this area. Private accessory structures, pools, fences are expected on single-family lots. Referenced the potential detriment to the public good. I think that there's actually an improvement with the fence that's proposed on this property because it enhances that landscape buffer and provides a better screening of what is otherwise allowed on the property. The patio, the outdoor seating, other accessory structures are not necessarily limited in this area. The pool being placed in that area doesn't necessarily change how they use a typical rear yard. And again, the orientation of the pool being behind the building and not off to the side and encroaching into the corner lot aspect really stays true to, as a planning professional and looking at other ordinances, what is that actual reverse frontage rear yard and not in the front yard of the corner lot. Because the other option, we could have come in and moved the pool over and approached into this area. We wanted to treat the back of the property like a rear yard, the way it should be treated, given the fact that it is a through property from street to street.
So is it your position that if this were a traditional layout for lots and this was the backyard, you wouldn't have to come before us?
Correct. We
Okay.
would meet all
just-
of the requirements, including the setback requirements, if it were a true rear yard. We would actually, if it were a corner lot, we would be here for the fence potentially, but, yeah.
Okay, yeah, I just
Yes.
wanted to make sure
Yeah.
that, pools are permitted in Cape May, and if this were a regular rear yard, you wouldn't be here. Okay.
Your association rules say that you have to be approved by a architectural review committee?
Correct.
Is there one yet, since most of these properties aren't sold yet?
I'll let Mr. DeForest speak to that.
Yes, sir. They approved the pool and also.
And the fence?
Yeah. We're in the final stages on the, it's very strict on the details of the house, and they haven't yet cleared all that, but this was fully
But it-
understood and agreed to.
I'm sorry, it stipulates that you must comply with the City of Cape May ordinances for fences. So this doesn't comply with the stated ordinance in the City of Cape May, so you wouldn't have gotten that approval as of yet.
Oh, well,
I mean, you got the approval perhaps for the pool, but it states in this document that you have to adhere to the City of Cape May fence ordinance, which does not permit 6-foot fences in a front yard, regardless of the configuration of the lot. It doesn't
I don't
nuance
think
that.
that the homeowners association is questioning that we have to come before you.
Okay.
And we are not.
Certainly, no, I appreciate that. I just wanted
I
to
don't want to see
clarify.
us get into a match with your association.
Yeah.
No,
Right.
no,
That's why we wanted to.
Mr. Andy knew full well and actually wrote saying we're okay to have this pool.
Okay, so some of the other things that are in your document, and I think go to my concern around neighbors present or notified, talks about lights, loud noises and sounds. You have some restrictions in your HOA document that speaks to that. We all know that an outdoor pool sort of invites and engenders, people being out there late at night. Noise carry is an open field. Number one, so, that would be an additional concern. I appreciate the pool's been approved, but it's an additional concern that, to have that, especially the way this subdivision is, and it's on a corner lot. It's going to be very open and, could potentially interfere beyond. Is this going to be a private residence?
It is a private residence.
Non-rental?
No, we have always reserved the right to rent in order to support our.
Okay. Thank you for clarifying that.
And I believe the HOA docs allow for it as long as.
Yeah,
we for
no, that's for my own
Correct.
edification.
Okay.
Thank you.
Understood.
I'm sorry, we interrupted you.
No.
Were you finished? I'm
I mean,
sorry.
I think we were pretty much.
outside of me summarizing what I said, that this is a unique situation. There's a clear hardship that impacts the property, but there's also benefits and purposes of zoning that I believe are advanced, or in my opinion are advanced, and that this is not an egregious ask in terms of the restrictions on this property and how we've tried to orient it so that it matches what a traditional rear yard would be.
Just a couple of quick, Ms. Mark, in Mr. Hurlis's review report, he does indicate that a landscaping plan, we would either need to request a waiver or present one. Do you believe that a waiver request is justified through this application based on what the applicant is going to have to abide by prior to
Yes,
building?
I believe it's justified. They have to abide by the subdivision plan that has the typical lot landscaping plan that's already been approved by the planning board, and so there really is already a landscaping plan detailed as part of the subdivision.
Okay. Anything else you'd like to add?
No, I think that covers it unless there's questions.
I want to ask Mr. Hurl, I asked Mr. Hurl a question before this started. I just want to ask it on the record, so everyone has the benefit of what I learned. Because Mr. Hurlis was here for all these approvals, I was not. And when I looked at this, I kind of reacted the typical way, like Ms. Morrissey would say, is pool in front yard. What's New York going to say? And, but what I asked Craig was, when this was done before the board, was it contemplated that this would have two front yards so that it would appear like a front yard from New York? Or was it contemplated that there was a front and a back? Because I was looking in these resolutions for somewhere where it said, because of the way it's designed, you have to make the front look like a front and the back look like a front, and design features to do that, kind of like we do on corners. Sometimes we have a corner lot, and we say to the people, when they want a variance, we want you to make it look like two fronts. So I was trying to see if there was something in these approvals that said, you need two fronts, and Craig.
Architecturally, no. They wanted the fronts oriented, so velvento splits the block right down the middle, so the lots on the other side of velvento will all face, as well as this side, will all face into velvento. So
Into what, I'm sorry?
into velvento, which is the new street that was just improved through there. So it was, the planning board struggled a little bit with this, and they knew that there was going to be an odd situation, and there may be variances, just like this applicant is here before us, because of the double frontage. And Cape May doesn't have many of these, so, and our ordinance doesn't really recognize that, and it's not written for that. So you have these situations, and that's what the Board of Adjustment is appropriate for.
If somebody wanted to put a shed.
They're going to come in. So the pool, the way the language in the pool is written is really what drives the pool situation, because the way that section 52562A1, I'm reading from the bottom of page 3 of 5. It says, under subsection C, the pools have to be, be set back from the front property line by a distance greater than the actual front yard setback of the principal structure to which the swimming pool is accessory to. So that means the face of the structure, like if you measure from the street towards the face of the structure, that pool has to be set back behind that. Well, in this case, you have, that requirement is based off of Baltimore Avenue, Velvento Avenue, and New York Avenue. So that side lot line is exactly where Tiffany's zone is the only place where this ordinance would not impact that. And there's no room because they've complied with all of the other bulk and area regulations. And you can see on Mr. de Blasio's plans, they've shown that envelope where the building is permitted. They've complied with that. They've met all of the other requirements, and there's no room for any accessory structures.
And we could request a variance to move the house closer to Baltimore, but even then, we'd still need a variance because you wouldn't have enough space to have that 10-foot separation in your ordinance. The pool requires 10 feet from the house.
Yeah, so.
To me, I see this almost as an interpretation of the former site plan. You're trying to decide whether they meant to prohibit accessory structures. I mean, because,
No, and that's,
I don't think they
the importance of that 10-foot wide landscape easement was the result of all of these discussions and deliberations with the neighbors and the board members. They're like, how do we deal with this? And the residents on New York, if I remember correctly, most of the residents that came out were on New York Avenue. And they were like, no, we would rather have the rear yards oriented towards New York Avenue. So, and the solution was, let's come up with this 10-foot wide landscape easement. It's going to buffer that, in addition to whatever, like fences or whatever, because we recognize there may be improvements in those rear yards.
But again, it's so unusual.
Yeah.
But for the fact of the way the lots are oriented or
Right.
where they agree to, they wouldn't be here.
Correct.
Okay.
Correct, absolutely. You're spot on.
Okay.
When did this property owner's list go out? You heard the last one that they went out?
It went out, let me see if I can tell you. Submitted the affidavit, we sent these out on April, let's see here, April 14th.
This year, okay.
Oh, how old's the list?
Yeah.
The list is from February 1st.
Of this year.
It's all this year.
Very recent.
That's more typical. The other one are just, for some reason,
That's
didn't get
sort of
heard
stuck
for
in my
a while.
head, like, because there's an applicant with a project behind my home, and been ongoing and ongoing, and people, he just keeps reapplying and reapplying, and there's been, so many neighbors have come and gone over the past 10 years or whatever.
I don't mean that, part of that is COVID, believe it or not, because the change of the tax roll depends upon the recording of the deed, and things weren't processing as fast as usual, so it doesn't seem like, so I had a case in another town where the tax bills kept getting sent somewhere else, and taxes didn't get paid, and we tried to figure out why, and it took them like 6 months to change the rolls, because things were just taking forever to move around the systems. It happens.
All right, so let's have your report, Craig.
So just quickly, I touched on the major things with regards to completeness. The only item is item number 33. That should be a condition of approval. The charts on page 3 of 5 indicate the structure is pretty much dealt with in the first table. It conforms with all of the other, we're not overdeveloping the site here. I mean, it's evident based on their compliance with everything. The pool is in the secondary table, and you can see where it doesn't conform with the front yard setback requirements, and I read into the record what that requirement is, and it's the specific language that says it has to be, the pool has to be behind the face of the structure as it's oriented to the street. So that's why they're dealing with that variance. And then the fence variance is separate and apart from that, and that's essentially, they're dealing with the 3 front yards there and the 6-foot fence height.
My concern with that is that we are setting just, on face value, a precedent by approving a 6-foot fence in a front yard, regardless of the configuration of the lot.
First, there really isn't much the concept of precedent doesn't really apply to zoning boards. Each application.
Okay,
is on its
all
own
right.
merits. But also, you're kind of not, because there
Okay.
really aren't that many properties like this.
This is a unique situation
Yeah.
here.
So we're pretty careful about fences in front yards.
But setback rules for corner lots apply, right? So it's
Yeah.
kind of, doesn't a setback rule also apply in this situation?
I think you would be approving this based on the unique situation of this lot.
Mm-hmm.
Essentially, the rear yards are oriented to New York Avenue where they're typically front yards, so.
Okay, all right.
So the situation that Ms. Worsey, I say it right?
You did, yeah.
I'm so used to the other. But that, for those reasons, I think it's unique to
Okay.
to this block.
Okay.
And it's 3 streets on one lot, which we don't see that often. It happens, but it's kind of, it's a peninsula, it doesn't happen a lot.
So I'll make this, the rest of this easy. Does the applicant agree to all the other conditions in my report?
They're reasonable, they're fine.
So they should be, those are brought from the previous subdivision approval, so those should remain as conditions of approval.
Just revisit number 33. I missed what you said, and there was some talk of not
Okay.
doing a landscaping plan. I want to make sure we.
33 was the requirement to provide a landscaping plan when they come before you. There's already one that's approved for that 10-foot wide landscaping easement, as well as additional landscaping. That's going to be provided as a condition of approval.
Rich, I think what I handed you earlier may be the adopted landscape, because that's,
Except you probably can't read the
yeah,
landscaping
you may not be
portion.
able to read it, but that is the landscape plan that was adopted.
Well,
So, but that gets reviewed prior to them getting a construction permit, and I do that review, so I support that waiver.
And just in terms of the uniqueness, if, in Cape May, if you're gonna have someone that has that three-sided lot, you're gonna have a double deep lot. It's gonna be an oversized lot, so you're gonna have more room to be able to use, which would make it this more unique because it's not an oversized lot. So.
I actually live on a corner oversized lot, so I'm sort of personally familiar with the sort of the.
I live on a front to front. I live on one of these,
Yeah.
actually.
How rare they are, but
Yeah.
here we are.
It goes from Windsor to Grant.
Right.
And your project came before the zoning board, too.
For me. Thank you for approving it. I don't think it would pass today.
Does this development, did they specify what kind of fencing you have to put up? I mean, did they say what kind? It's
not-
going to be
it's not
individual or
reflected
everyone?
In the governing documents of the association. They do have the review committee that can
Association.
go over that with each application, each individual that comes in, but there's no restriction or
No restriction on what kind?
placement as to.
And I know we don't have the landscaping plan, but just to, I just want to understand. Is it, 10-foot high evergreen shrubs? I mean, what is going to block this fence from people on New York Avenue looking across and seeing 10 different kinds of fences potentially?
At the time of planning, I think they're 6 to 10 foot.
Okay.
The landscaping that's out there right now
Yeah,
is not acceptable.
right,
So,
yeah.
so as the developer put those out there,
Yeah.
when they put the street improvements in there, trying to get off the bond, and we did not approve that. So as these homeowners come online, we're having those buffers reinvigorated and reestablished. Because a lot of the material's dead.
Yeah, I didn't want to say anything, because
Yeah.
when I drove out there, I'm like, this is really not.
Yeah, not acceptable.
But if
Okay.
that's what
All right.
Craig's board approved, I'm not
Okay.
going to
No,
say
we're
anything.
not
No.
approving that.
I had
I'll go on the record, we're not approving that.
because I thought it was a little
Yes.
skimpy.
Chairman, you ready for a motion?
I'm ready for a motion. Oh, wait, we didn't open it to the public.
Nobody's there.
Or now?
Yeah, seeing that there is no public, we'll close it to the public.
If there's no further discussion, the motion I recommend being made is a motion, we always make them in the affirmative, doesn't mean you have to vote yes. It's a motion to grant the application with variances 1 and 2 on page 3 of the engineer's report, with a waiver of the landscaping plan because it's subject to the subdivision's landscaping plan and the other conditions outlined by the board engineer. And this is a simple majority vote, unlike the prior one.
I'll make the motion.
Yeah, there you go. Go ahead, Mary, you make it.
I'll make it.
Second.
Motion by Mrs. Nodge, seconded by Mr. Ledwin. Mr. Walsh?
No, to me, it's still a pool in the front yard. There's no getting around that.
Mrs. Notch?
Yes.
Mr. Ledwin?
Yes.
Mrs. McDade?
No.
Mr. Venuto?
Yes.
Mr. Murray?
Yes.
Mrs. Hutchinson?
Yes.
Thank you.
5-2. Thank you.
Thank you. Appreciate your time.
3 front yards.
Do we have a motion to adjourn? Thank you.
Second.
All in favor? Thank you.
At least somebody left your hand tonight.